Please, sir. Well, on one matter, item number 37, my lord. Motion.
Yes.
My lord, there is a separate cause of action which arose. All the time it happens, my lord. So I thought that let me withdraw it with a liberty to file a fresh one.
Mr. D. Das, Learned Senior Counsel, stated by Mr. D.P. Bora. Learned Counsel for the petition has submitted that in view of a fresh cause of action, the petitioner wants to withdraw the writ petition with the liberty to file a fresh. Okay, anybody? You were respondent.
No.
I would like to get.
I know it is not.
1 minute, sir. 1 minute, madam. In view of the above submission made by Mr. Das, Learned Senior Counsel for the petition, the writ petition is dismissed on withdrawal with the liberty as prayed for.
No. Deeply obliged.
It is urgent. I wanted to get a case that it has already been registered. The very urgency is there because from tomorrow, last week is started for giving the bid.
Huh?
For giving the bid. My tender is concealed. After taking the LOI and taking the bank guarantee. So immediately retender has been made and from tomorrow there is a bid opening day. So I want it get it listed
Subject
by
to time
tomorrow.
permits.
Beg
This
your
court will rise at 2:45. Subject to time permits.
It's very urgent, Your Lord.
Subject to time permits.
Much of it.
Meet your lord. I am praying for listing of these two new matters, my lord. Along with item number 26 of the lordship's cause list, supplementary cause list, my lord. So this is fine. Item number 36, connected with item number 36, same matter, my lord.
36.
Yes, my lord.
You want unlisted?
Yes, my lord. These two motion matter, my lord.
Huh?
Along with item number 36, my lord.
Why?
The matters are same, similar matter, my lord. We have challenged the same so-called blacklisting order, my lord.
36.
Yes, my lord.
Blacklisting.
Yes, my lord. Supplementary cause 36. Supplementary cause list. My lord.
Subject to time permits.
My lord, my lord.
May please, your lordship, I make to mention item number 5, my lord. Matter may become after 4 weeks, my lord. The concerned party is posted out, my lord. He is going to post it out today, my lord. Item number 5. I have to take some instruction from them, my lord.
On the request of Ms. A. Gayan, Learned Counsel for the petitioner, this is the case?
Item number 5, my lord.
After what?
After 4 weeks, my lord. 3 weeks.
Why motion made
3
up
weeks,
4
my lord.
weeks?
3 weeks, my lord. Because he is posted out, my lord, next 3
This is the
weeks.
case on so and so.
Master bless.
First, may please, your lord. But if I beg to mention a motion matter, I was granted the LOI when bank guarantee was taken. After that, I was terminated with him, either on Wednesday or Tuesday. Lordship.
When is it?
May it please your lordship, we took the concern of the petitioner advocate MS J. Paul. We want to mention item number 16, your lordship. May it be listed after 2 weeks.
Your lordship, date may be fixed. It may be taken up after vacation.
Item number 16.
Yes, your lordship.
You are for whom?
We're the respondent number 4 for the hospital.
I am for petitioner, your lordship.
Okay. Miss,
Date may be fixed.
Miss, your name, please.
I am on behalf of J. Paul, S. Bhomik.
And Bhomik, Learned Counsel on behalf of Ms. J. Paul, Learned Counsel for the petition is present. Mr.
J. Hawk.
J. Hawk,
Yes, your lordship.
Learned Counsel for the respondent 4, has sought listing of the case after 2 weeks. First of, as the Learned Counsel for the parties for agreed for an adjournment, list the case on sides.
27 April, 27th court.
May I please your lordship. Lordship, with the consent of the other side, I beg to mention item number 9, 10 and 11, your honor. The senior conducting counsel, there is some personal difficulty. So if the matter can be adjourned for 2 weeks.
Okay, on the request of Mr. D. Khan, Learned Counsel for the petitioner, list the case on so and so. 10, similarly. You have informed us other side.
Yes, sir.
That consent has been taken from the Learned Counsel for the respondents to make the prayer. But place the case on so and so.
3003.
May it please your lordship. With the consent of the other side, I beg to mention item number 16, my lord.
16 just now
16 mentioned.
mentioned.
Just now mentioned.
Please, Lordship. Lordship, with the consent of the other side, I have to mention item number 15, Lordship. Lordship, we are going to file a reply, Lordship, to the affidavit in opposition filed by the respondent, Lordship.
Today.
No, Lordship. Within this week, Lordship. Can it be taken up after 10 days?
Mr.
Lordship? W. Rahman on behalf of H.
W. Roman Learned Counsel appearing for a petition has paid for and is granted to his client to file an affidavit in reply. Full stop. It is submitted that consent has been taken from the Learned Counsel for the respondents to meet up here. Release the case on sides.
6th April. 6th
I-
April.
I'm for this.
Okay. It's
Legal aid counsel.
empowerment. The legal counsel appearing for the respondent has consented to a prayer. Raise the case accordingly on sides.
Daily list for motion, items 1 and 2.
Melo, in terms of the directions, they have deposited 40 lakhs, Melo, and we have received. Now, Lordship, can you see page 21? Up to May 2025, the quantum of liability 90 lakhs and as on today, Melo,
Page
21, Melo. 28, sorry. This is May 2025. Paragraph 2. Now, Lordship may place one document.
Yes.
No, Lordship, one document I like to place. Present position liability is 1 crore 32 lakhs, my lord. Therefore, Lordship, may I pray one thing is subject to a Lordship consent that 40 lakhs they have deposited. Rest amount, my lord, they required to be, my lord, long outstanding figure. And my lord, second thing is that the unit is not in functioning, my lord. If suppose Lordship keep a interim order continue, my lord, then definitely neither serve their purpose, my lord, nor us. Suppose Lordship give a particular period of time to deposit the rest amount, my lord.
Now
Subject
you say that it is 1 crore 32 lakhs.
my present liability.
Yes, Mr. Sharma.
My lord, Lordship, kindly come to page 34, my lord. And that page 34, my lord. Second paragraph, my lord.
Where is the tripartite settlement?
50 lakhs was directed.
Where is the tripartite settlement?
My lord.
Where is the tripartite settlement? Where is that? It has to exist on paper.
Yes, my lord.
Where is it?
My lord, my lord, if you were directed to produce the record, my
No,
lord.
where is the detail that tripartite settlement has been made?
My lord, no settlement was there, my lord. My lord, but
No settlement was there, and how can we?
But one meeting was held, my lord, and from the minutes of the said meeting, my lord, it will be revealed.
Where is the detail? They're minute.
My lord,
From
this is-
minutes.
My lord, this is the minutes, my lord.
Now, where is that? In the read petition?
My lord, I have stated, my lord, in my lord, paragraph 5, my lord. Paragraph 5, my lord, page 11, my lord. The petitioner states that in the meantime, on 3/4/2021, a meeting was held between the principal secretary and the members of the industrial unit, Mamuni Gauhati. In the said meeting, following issues were discussed: the challenge faced by the industrial units of the industrial estate, Mamuni Moidam, during the lockdown period caused by so and so, how the best AI district and the government come together to address the challenges. And lastly, steps required for improving existing infrastructure in the industrial estate, Bamuni Moidam, to user in a conducive industrial ecosystem so that the government can accordingly plan the budgetary estimates.
In the said meeting, several resolutions were adopted, and among them, one is to settle the issue regarding enhancement of rent through dialogue across the table, payment through EMI, and further impose simple interest on default rent payment method. So, on the basis of that.
Annexer 1, where is it annexer 1?
Erroneously, I have that
Oh, Mr. Sharma, it is so casually filed. You are a chronic defaulter. You are a chronic defaulter. Now, here is a annexer 1 is something else. Synopsis.
Some,
This is
my fault,
this court tried to help you out, but you are creating more difficulties.
somehow, it is.
So casually filed.
Sorry.
You refer about minutes, then minutes or something else has been annexed. Now they are coming up with 1 crore 32 lakhs.
So, this is the minutes, my lord.
My lord, may I pray one thing, my lord? What happened, my lord? The unit which has been now there.
Despite efforts, I could not.
My lord,
I'm not in a position to
and
help
my
you.
lord, in earlier petition, my lord, notice has already been issued, my lord.
Notice has already been issued, Mr.
Some
Sharma.
protection was also given, my lord.
Coordinate benches
Yes, madam.
had extended time and again.
Yes, my lord.
Right. More than 12 months have elapsed. Your check bounced.
Not 12 months, my lord. That, my lord, that.
Shall I count? You want to justify?
No, my lord, I have.
No justification is left.
My lord, I have tried to explain, my lord, due to minor illness, my lord.
Whatever it is, and not a case, you are admittedly you are a chronic defaulter, mister. It is only mercy. Your case is on mercy
It is
jurisdiction.
a case of livelihood, my lord. Otherwise, I'm my lord, running that.
That is why court tried, Mr. Sharma.
Yes.
Court tried extending time and again. Shall I record that? Then it entails dismissal at the motion stage itself.
My lord, last opportunity should be given, my lord.
What last opportunity? How many last opportunities? Shall I count? Shall I count? Mr. Sharma?
4, my lord.
How many? Shall I count how many?
4 times. my lord.
4 times.
But
Last opportunity.
my lord, I'm depositing, my lord. Now 42 lakhs I am depositing, my lord. I have
And what
already
about-
deposited, my lord.
Lordship, rest payment, Lordship may fix a time frame to deposit the rest amount, my subject to my lord, continuance of this.
But my lord, proper verification and my lord, that my lord, the nego.
Yes, my lord, let them put any dispute, my lord, no problem. A time frame may be given, my lord.
Till February 2026, 1 crore 32 lakh. How much you have paid now out of that?
My lord, 50 lakhs something.
40, my lord, 42 lakhs last check.
Now 42 lakhs, my lord, and my lord, previously 9 lakh 50,000, my lord.
Where is that statement?
And from their communication, my lord.
Have you annexed here?
No, my lord, next, it is. received-
What do you have annexed then?
My lord, it is received on, my lord, September, my lord, 2023.
My lord, our calculation is based on all receipt and deposit, my lord, payment, my lord. Whatever, my lord, let them
I
pay the.
have deposited 50 lakhs, my lord, as per directive.
So what is your proposal agent date?
My lord, let them file their, my lord, response, my lord, that, my lord, it is a disputed amount, my lord. And my lord, from record, my lord, it will be revealed that, my lord, that.
Nothing is there. You are at mercy now.
My lord, it is.
After extension of time by the coordinate benches and this court for 5 times as a last opportunity, you failed on all 4, 5 occasions. Now, don't tell me that it is disputed amount now.
No, my lord, I have now deposited, my lord.
No, that total amount has not been
Yes,
deposited.
my lord. Yes, my lord, 42 lakhs something and my lord, plus 9 lakhs, my lord.
Yes, the calculation is quite clear.
My lord, can you see our, my lord, total, last column, total
And
payment.
after the resolution of the board, how can you you cannot set aside.
My lord, page 34, my lord, 50 lakhs was directed to deposit, my lord, minus the, my lord, already paid amount, my lord.
No, my lord, that has been dishonored, my lord. Check.
No, my lord. For the petitioner for payment of rupees 50 lakh against the total outstanding of 99 lakhs has been rejected in your decision taken by the Board of Directors. I'm 34.
Can you understand the meaning of this? Considering the petitioner is in possession of the allotted space for many years and is willing to deposit 50 lakh after deducting the amount already paid.
Yes, madam.
So
Yes.
it should be 50 lakh
Yes.
at first. Whatever you have
Yes.
deposited earlier, 9 lakh is
No, my lord, it
not
is the
part of 50 lakh.
my lord, it is the contents of the petitioner that in terms of the paper.
Oh, Mr. Sharma, your contention will not survive.
My lord, Lord, kindly come to the last paragraph, my lord. Considering that the petitioner is in possession of the allotted space for
Yes,
many
please
years
read.
and is willing to deposit 50 lakhs
Willing to deposit 50 lakh.
after deducting the amount already paid.
What is the meaning?
My lord, 50 lakhs minus,
50,000, then 50 lakh net.
my lord, 50 lakhs minus, my lord.
That is not the meaning.
Understood, my lord.
That is not the meaning, perhaps.
My lord,
If my understanding of this sentence,
my lord, considering that the petitioner is in possession of the allotted space for many years and is willing to deposit 50 lakhs after deducting the amount already paid within a period of 15 days from in the interim, it is provided that interim so and so shall not be given. It is made clear
kindly
that
see-
this interim order is subject to the payment of 50 lakhs minus the amount which is stated to have been deposited, subject to verification.
so what is the understanding of this?
This is my
50 lakh net.
My lord,
Is
my
it not?
understanding is.
What is your understanding?
Willing to pay, मतलब they are going to pay.
My lord, last kind of
It is your submission.
my lord, minus the amount which is stated to have been deposited, subject to verification, my lord.
What is this?
So, my lord,
So 50 lakh net.
50 lakh minus, my lord, that amount, my lord. What I have understood, my lord.
Lordship, can you see the sheet, my lord? The last payment which was made, page number 3, 2017, 5 lakhs, my lord. There we have given the, my lord, Excel sheet, my lord. There is no any dispute to that effect, my lord, about receipt of the amount. Not a single rupee, my lord.
50 lakh, mister. It is your submission. Minus the amount already paid. After deducting the amount already paid. Then let us see the following order. Come to page 39.
Yes, my lord. Having the third paragraph.
Accordingly.
My lord. Having considered the submission and the observations made in the application, I find that prayer for extension 7 days to deposit the amount 50 lakhs after deducting the amount already paid appears to be reasonable. According to application is granted further time 7 days to deposit the amount and so only after deducting the amount already paid. Only after deducting the amount, madam.
Come to page 42 again.
Yes, madam.
Para 8. Now this removes the ambiguity now. Para 8.
Yes, madam. That in view of the matter that this court allows the applicant with petitioner an extension till 23rd of October 2025 to comply with the order dated 29, it is made clear that the interim order would continue to operate till so and so, and only in case the applicant with petitioner make the deposit of the remaining amount of the proposed 50 lakhs to the AIDC on or before 23rd. That the interim order shall continue till the next date listing so and so. Remaining amount, madam.
Where is their termination order?
My lord, page
First one, madam.
51, my lord. Annexure 11, 5th December 2025.
So, Assam, is this as per the Assam Public Premises Act?
No, my lord, it is not in terms of the public premises. It
Ah.
is the first action that we have contained in our own act. After we handed over to the, my lord, state
Show us
officer.
your act.
My- And we have contemplated action in terms of our, my lord, industrial policy.
No, statute policy cannot perhaps
My lord, no, no.
prevail over
Absolutely. But
your state, your own statute.
statute, my lord, that given the power to the state officer for eviction.
May by notification provided from such date. As is stated therein. Is there a notification under subsection 2 of section 30?
Yes, my lord, that
Where
notification,
is
my lord, that is now in our office, lordship require, my lord, the process is such that, my lord, in terms of the lease agreement, if suppose default, then we have a right to cancel the lease, my lord, leaseholder, that we have exercised. Afterward, my lord, in order to recover the position, my lord, then my lord, state officer come into play. Now, that purpose, my state officer already appointed by virtue of notification issued by the government of Assam, Industry and Commerce Department. Therefore, my lord, after cancellation, we handed over to the, my lord, state officer for needful action, my lord. Now, once this action was initiated, they came to know, they filed this writ petition.
Where is the notification?
My lord, notification, my lord, I have to call, my lord, from the office, my lord.
So it will be after for eviction. It will be under section 7 perhaps, no?
Yes, my lord, yes, my lord. Public premises, they come into play.
Estate officer will come into play.
My lord.
Then there is a provision for hearing.
Yes. I think that notice to
Areas
that,
of rent variable
that was under process.
required at the period of same. There was earlier litigation?
Yes.
Earlier there was litigation.
My lord, that is item number 2, my lord. That was pursuant to that, my lord, once we initiated.
One.
I will to read petition.
It was a দুটা আছে না?
Oh, Then there is an appeal provision, my lord, against the cancellation, my lord, if they would like to challenge, my lord.
Which one?
My lord, suppose we have issued the cancellation, they're dissatisfied, then they can prefer appeal in terms of our, my lord, policy, my lord, 2021, because policy is also applicable in terms of the act, my lord. Last time I placed, my lord, that.
What does this judgment held?
My lord, this was pending, my lord.
No. Annexer. There is an detailed judgment, page 40.
Page 40, my lord. My lord, this was disposed, sorry, my lord,
Definitely disposed of.
yes. My lord,
I'm not saying that it
yes,
is
yes,
not
absolutely.
disposed of.
Yes. Well, hey, my lord, that was appealed, my lord. The challenge was which was made. By page 71. Page 30, my lord, page
Come to
30,
page 51.
and
51, 50.
and outcome is, my lord, page 70.
No, come to page 51.
51, my lord. Yes, my lord.
The power to oversee the functioning of the corporation has been retained with the state government under section 19 of the Act. Then, with regard to the applicability of the Assam Public Premises Eviction of Unauthorized Occupant Act 1971, provisions are contained in section 30 and 31 of the Act. So section 30 is made applicable.
My lord.
The industrial state is public premises.
Right. Because, my lord,
So
the
public premises means it is not only 7.
yes.
It is not only 7. It will start from 4, section 4.
Yes, the procedure, my lord, that has
Ah.
been laid down, my lord, that has been followed.
Procedure
state
laid down
officer
in
will-
public
yes,
premises.
State officer will
First-
issue.
You have to issue a notice to show cause against.
Yes, my lord. The state officer issue notice, give them 30 days time, whatever, my lord. in terms of
Thereafter
law.
hearing.
Yes, my lord, no doubt, my lord. That's
Thereafter hearing. Thereafter a final order under
Yes,
section
madam.
6.
Yes, my lord.
And thereafter, for recovery of rent,
My lord, then,
section 7.
yes.
So nothing has been followed.
No, my lord, that part restrained because, my lord, after filing this rate petition, my lord, what happened, the state officer be handed over to the state officer. Now, while that process was initiated,
So he'll be in possession till the provision is not.
yes, my lord, position they are there. There is no problem to that.
Ah.
My lord, question is that, my lord, because lordship has taken up this matter, therefore, my lord, the action that has to be contemplated, my lord, that has been stalled, my lord.
Mr. Sharma,
My lord.
Let them deposit, my lord, because lordship only one prayer, my lord.
see, we tried to help you,
Fine.
but you failed. No case is made out. You have not taken any plea. You have never referred to this. In order to help you out, the court itself
My lord.
has referred to it. You sought extension after extension, and court continued to grant you last opportunity. Now, 50,000 you paid, but that is disputed. They are disputing it because there is no concrete agreement.
My lord,
No concrete agreement. No concrete agreement. Ultimately, it has to be by the standard rent as per the Act, which you have to pay. I thought that you'd be able to make out a case now that from 19 lakh, it has increased to 1 crore 32 lakhs.
Lordship, may I pray only one thing, my lord.
Ah.
They are occupying 5,000 nearby square feet. Now, problem is that, my lord, so many unemployed now youths are applying for, my lord, getting, my lord, lease property. Now, neither they are using, my lord, nor, my lord, it has been used by the new, my lord, incumbents. Problem is that, my lord, if suppose they would like to carry out the activity, my lord, it's some good purpose. Now, just occupying that premises, my lord, there is a double, my lord.
Oh, yes, court is aware of the fact they are
Yes, ma'am.
in occupation of the property since 1960s
Utilize,
or 1970s,
Yes.
right?
Yes.
So that is also a factor. Just because of COVID,
My lord. No, my
their
prior
whole
to-
operation got impacted.
But prior
Just
to
because
COVID,
should not be thrown out also.
So,
So
what I'm
your
saying-
action is also not.
My lord, my purpose is, my lord, saying that if suppose they utilize, because our intent is
They are
to.
saying they are utilizing it.
No, absolutely, my lord. Prior to 2000, my lord, prior to COVID, this unit is closed, my lord. There is no any functioning, my lord. My lord, that verification report is very clear on that point. Question is that if they utilize, my lord, we don't have any problem because that is their, that is our purpose. Neither they are utilizing nor, my lord, new, my lord, persons are getting entry, my lord, into their premises, and it's a very valuable property of Bamuni Maidan.
Yes, that I am also aware.
Let them pay the amount either or to, my lord, allow us to evict, my lord.
Okay, in the meantime, you sit with, because you have said hard, Mr. A.K. Sharma. Learned counsel for the petition. Who is for respondent number one?
Industry Department, Government.
Received us learned additional senior government advocate for the respondent number 1 and 2. And Mr. S. Somoria, learned standing counsel, Assam Industrial Infrastructure Development Corporation. For the respondent number 3 and 4. Stop. Para. The petitioner has projected that after being allotted an industrial seat in the industrial estate at Bamuni Moidam, Gauhati, in the year 1964-1965 by the state respondents. AIIDC was born in which year?
My 17 years, my lord, under this act, my lord.
Which subsequently came within the administration of the Assam Industrial Infrastructure Development Corporation, established under the Assam Industrial Infrastructure Development Corporation Act 1990. The petition has been operating its business from the said industrial seat. However, during the time of COVID-19 pandemic, the business of the petitioner had suffered badly and there was default in depositing the fixed rent against the industrial seat. Full stop. Mr. Sharma, your petition is badly structured, badly prepared, badly drafted. A show cause notice was served upon the petition on 28/5/2025 by the respondent AIIDC, stating initially that the petitioner's unit was found non-functioning for several years and outstanding dues against the allotted industrial seat got accumulated to 99,26,461 as on March 2024. So it was further mentioned that the waiver of outstanding dues was sought for by the petitioner with an undertaking that they would pay an amount of rupees 36,34,706 against the total outstanding. The board of directors of the AIIDC in its 35th meeting held on 26/3/2025. Arrived at a decision that no financial waiver could be considered due to non-functioning of the petitioner's unit for more than 15 years. Post of. The petitioner has claimed that the industry was running from the industrial state till 2023. Post of. Para. The petitioner has referred that initially petitioner was served with a statement of an outstanding due of rupees 2,21,18,556. Post of. Subsequently, it was recalculated after a meeting of the meeting held by the Principal Secretary to the Government of Assam Industries Department on 3/4/2021 with the AIIDC officials. Post of. Where is your Mr. Sharma? Come to page 30.
Yes, my lord.
Second para.
Yes, ma'am. Thereafter.
What is the basis?
My lord, thereafter, that then MD so-and-so, his presence of GM so-and-so, called for a meeting in which he has asked us to raise the due amount from 36 million and the department will come down so-and-so and finally amicably settle on him and which was placed the chairman so-and-so. But so my record will, if the
Mr. Shamoria?
My lord.
How can he say this one? Page 30. He is sticking to it all throughout.
My lord, so far the settlement part, my lord, which they are insisting, my lord, that was subject to, my lord, the claims of the amount which suppose he agreed to pay it upon.
No, up to settle at rupees 50 lakh.
But there is no such record, my lord,
And
that
my lord-
50 lakhs was, my lord, might be suppose, my lord, it was offered, but my lord, can you see that since we have acted upon afterward cancellation, suppose, etc. My lord,
My lord, as per
that
my
situation
instruction,
no more remains, my lord.
my lord, as per my instruction, my lord, record will prevail and
The records, my lord,
noting-
once acted upon, was both sides agreed upon that amicable, my lord,
Lord,
since he failed to, my lord, comply with the
noting
terms
is
of the,
there, my lord.
that's why we have
In
proceeded.
a reply, comma, nobody is telling the truth. That is the problem.
No, as per my instruction, that noting is there, my lord.
Nobody is
Initial
telling the
record.
truth. That is the problem. In its reply submitted to the so-called notice, the petitioner had earlier stated that the respondent number 4 called for a meeting wherein the petitioner offered an amount of rupees 36,34,706 as one-time settlement amount, whereas the department proposed an amount of rupees 99,26,461. Full stop. It is the case of the petitioner that finally the parties had amicably settled the matter at rupees 50 lakh. And the matter was to be placed before the board of directors of the AIIDC. Full stop. But without any mention of the state amicable settlement. The petitioner had served the show cause notice on 18/5/2025. Full stop. Subsequently, by an order dated 7/8/2025, the response number 4, invoking in exercise of the powers conferred under section 16 within bracket D of the AIIDC Act 1990, cancel the allotment of the petitioner's industrial estate on the ground that a sum of rupees 99,26,461 as on March 2024 has remained unpaid towards lease rent, and the petitioner, despite grant of opportunities, failed to clear the outstanding dues. Also, after notice, show cause notice dated so and so, and the cancellation order dated 7/8/2025, the petitioner has approached this court by a way of a writ petition WPC number 4889/2025. By an order dated 29/8/2025, the court, while issuing motion, or notice of motion, had passed an interim order to the effect that I had observed in the interim that as the petitioner was in possession of the industrial estate for many years and was willing to deposit a sum of rupees 50 lakh, after deducting the amount already paid, within a period of 15 days therefrom, the order of cancellation was kept in abeyance for a period of 15 days, subject to payment of rupees 50 lakh, minus the amount which is stated to have been deposited, within bracket subject to verification, within a period of 15 days. Failing which the interim order shall stand automatically vacated. Would stand automatically vacated. First of thereafter, the period of 15 days to deposit the sum of rupees 15 lakh was extended on a number of occasions. Most of it is a case of the petitioner that at an earlier point of time, the petitioner had deposited what, rupees 9 lakh? What is the amount? Tell me, what is the amount?
Yes, Mother.
There is no whisper in the writ petition,
Yes,
neither of the writ petition.
9,57,337.
9,57,337.
7.
And finally, in the month of March, the petitioner deposited the remaining amount of rupees 40,42,663 out of the rupees 50 lakhs. Full stop. Para Mr. Somori Alliance Standing Council has submitted that after the order of cancellation. Dated 7/8/2025. Comma, an eviction notice has been issued to the petitioner on 11/2/2026 by the estate officer. Full stop. The provisions of by virtue of section 30 of the AIIDC Act 1990, the provisions of the Assam Public Premises with in bracket Eviction of Unauthorized Act 1971 have been made applicable. First para. And after completion of the exercise, after completion of the procedure formalities as envisaged in the Public Premises Act 1971, comma, the necessary action for eviction of the petitioner would be undertaken. So on query, the constable petitioner submitted that the have you received this notice? 11/2/2026.
No, man. No, man.
Huh? The petitioner has not yet received a notice issued by the estate officer on 11/2/2026. Full stop. If not, if the petitioner has not received the notice, command the respondent AIDC or the estate officer shall take necessary steps for service of the eviction notice upon the petition. Full stop. The matter would require consideration, issue notice returnable on so and so. Bihur Bishop Diriba. As Ms. Das has appeared accepted for 1 and 2, Somoria 3 and 4, no formal notice. Heard the learning council for all parties on the interim period. full stop. Admittedly, comma, as on date, comma, the petitioner has deposited a sum of rupees, an amount of rupees 42 lakh. Lakh 42,663. In addition to a sum of rupees so and so, within bracket subject to verification, 9 lakhs so and so. Full stop. The petitioner is granted liberty to submit an additional proposal for deposit of the remaining amount before the respondent AIDC authorities within a period of 15 days from today, or within a period of 15 days from today. And the respondent AIDC authorities on receipt of the proposal itself give due consideration to the same and apprise this court on the next date of this thing about the decision taken on the proposal. First of till then, there should not be further coercive action against the petitioner in terms of the cancellation of the dated file. Submit a proposal,
2704.
15 days.
27.
Let us see how is their proposal.
Item 3.
I'll list the case on so and so along with WBC number
Both have.
4889/2022.
2704.
May it please your lordship. In this case, the state has supposed to file affidavit in opposition on or before 6/3 lordship, but they have not yet filed. But respondent number 9 has already filed.
Some more claimant has come.
Lordship. So.
Another claimant.
Lordship.
Who is that? Mr. Borthagun.
Item.
That day he was projecting.
Lordship, we need to file a implement application in that matter.
State.
No, the main grievances is against the Gauhati. Gauhati secretary has already filed their affidavit. If required, I'll go through it.
Affidavit is filed, has
Yes.
it filed?
It's
Not tagged with the.
We have filed it, my lord, but
13(3).
it has not come on record, my lord.
You are
I am respondent number 9. I am the president of the Gaon Panchayat. I represent the elected body of the Panchayat.
Patari Hara Gaon Panchayat.
Right.
Yes, lordship.
Basically, you have to have Gaon Panchayat permission and plus government approval.
Government approval.
And thereafter, the issue of day of the market.
Yes, lordship.
Gaon Panchayat permission you have got.
Yes, lordship.
You have got.
Yes, lordship.
Government approval
Government approval yet to receive, lordship.
yet to
We
receive.
have applied.
Thereafter, day of the market.
Lordship, day from 2019-14, we are running only on Friday.
Right.
Now, lordship,
But
item number
now,
4
as
is.
on that, you are without government approval.
Lordship.
In spite thereof, my lord, I may point out, taking advantage of the writ petition pending here, they are going on with the illegal market.
Those are disputed facts. We do not now want to enter. So what is the government approval when it is coming? Because there is a clear direction perhaps
Yes, lordship.
Correct.
by the
will see.
colonial banks. Some misconception was there. So come to page 91, Mr. Doctor.
My lord.
The second writ petition was disposed of, lordship.
Page
Paragraph 14.
91. Page
Yes,
91.
lordship.
Roman,
Paragraph
paragraph
14.
14, Roman 3.
Yes,
By the additional chief secretary to the government of Assam.
No, regarding that matter, I'll take instruction, madam.
Because once approval is granted, then only they will be able to operate.
Yes.
lordship. And lordship, only approval, NOC is already there, lordship, and Panchayat already given permission,
Once they are given,
lordship.
but the court has held. Please come to the
Lord.
earlier decision.
Paragraph 3, lordship, that is
Paragraph,
submitted that in the.
paragraph, come to page 80, 81.
That was the earlier petition, Lordship,
Ah.
and thereafter that was modified.
Petition have already been granted, no objection by the district commission, all are set aside.
Lordship.
And court has interpreted that the concerned Panchayat authority will be Gaon Panchayat.
Yes, Lordship.
Gaon Panchayat has given it.
Lordship.
But government approval is yet to be there.
Yet.
Without approval, how can you
Lordship.
claim?
Lordship, that we have already prayed and our petition is
Prayed,
there,
right.
Lordship.
But he is sitting over the matter,
Lordship.
is it not?
Lordship.
There is a clear direction.
Yes, but this case, my lord, it's not parties to seeking direction for their government approval, my lord. Only Friday, my lord.
Right, Friday will, firstly,
I can take
First-
instruction on that, but.
firstly, the committee must have the, this Bazaar cattle market committee or cattle market must have the government approval.
Lordship, there is a clear direction to give within a period of 30 days, Lordship.
That is what,
Lordship. According to
91.
right also. Lordship.
91,
Yes, Lordship.
then only thereafter you can contest Friday, Wednesday,
Absolutely.
Sunday.
Lordship.
I don't know whether the other markets, all this page 97, so many markets have come up now.
Lordship.
Come to page 97. So many.
Lordship.
Tuesday, Wednesday, Thursday, Friday, Sunday.
On every
Saturday,
day,
every
on
day.
every day there is
Every
one day,
day.
Lordship.
So you must have the approval.
Lordship. Lordship, let them file the affidavit, Lordship.
Mr. There is a clear direction.
My lord, I'll take instruction on that, my lord.
That was passed in which month?
24th September.
24th September, 6 months.
Huh?
19,
Oh, that there was a subsequent writ petition.
19.
Page. It starts from page
84, Lordship.
84. That is in
7390, WPC 7390.
19/12/2025.
19 December.
So it is 3 months. Now whether this plea will come now, code of conduct. I think court's direction will not come in the way.
And we have approached, Lordship.
30 days.
2912, Lordship.
And this is an inter-party order.
I'll take instruction on that, my lord.
And secondly, the other part, which the court observed. How you have devised the procedure of allotment on a previous date. Their claim is that they were operating the market since 2013 on Friday. So how have you, Gaon Panchayat have devised the formula to allot?
I have to.
If it is, it cannot be discussion then. If all are claimant for Friday,
That cannot be.
something like, say, lottery.
Yes.
Yes, Ms. Chaudhary.
Lordship.
And my lord,
If all are claimants for to run the market on Friday,
Lordship.
then if more than one candidate, some procedure has to be devised,
Lordship. I
right?
have no objection if anyone run on Friday, Lordship, but Lordship, my case is that we were running since 2013. These are the markets, Lordship, came up later.
Maybe they have some discussion to say allot or devise a procedure that one market on each day. Then also some procedure has to be devised.
Lordship.
Cannot as per the choice of the Gaon Panchayat members. So both.
My lord, may I suggest one thing, my lord? Because it is cases of motion stage itself, my lord. Lordship may issue a short notice, my lord. I can take it proper instruction.
And who is Mr.
16.
Sound?
My case is also right.
No, you have to, because I spent some time, got confused with all these facts. I got confused.
there in the earlier ground of writ petition,
Wait a minute, Mr.
And in this case, my lord, they are making some prayer against us.
Wait a minute, please.
We
Wait,
have not
wait,
made
madam,
a-
wait, madam, wait.
Sorry.
Wait, madam. Do you have the earlier judgment?
Lordship, that is your lordship.
In the third, item number 3.
I mean,
Uh,
we have not filed petitions in the,
wait. You have to answer
Lords.
the query of the court.
It's 80 of the earlier petition.
No, one, I have seen. Your names are
My name is your Badrul Islam Talukdar,
and
and your lordship will,
Abdul Malik,
lordship.
Samesh Uddin.
My lord, may I submit one point, my lord? It's very vital.
Let me make, otherwise I'll forget. Don't interrupt. Oh, don't interrupt, please. This,
Your lordship,
Abdul Mojid.
lordship may kind,
1 minute, mister. Please,
Lordship.
let me convey my message
Lord-
thereafter you.
lordship,
This Abdul Malik,
Malik, your lordship.
in item number 3, Abdul Malik
Abdul.
and Odut Mullah or Abdul Wadud, right?
Kodut Mullah.
Abdul,
Right from 2014,
lords,
they are in litigation
lords,
on the grounds 5 bigha,
lordship,
so and so lesa, kotha, and Friday.
lordship.
Right. Ms. Chaudhary, you have your petition. Please hand it over to him. Now come to page 26.
Lords,
Second para, the case setup.
lordship. Petitioner number 1, your lordship. is
The case setup
Lords,
by the writ petition.
lords,
Abdul Mojid and Odut Mullah.
Olut Mullah,
Right.
lordship.
They say they have set up the market, Gaurnagar, Damri Bhasa,
Lord.
Rees, Tiniali, Pokuhat
3 bigha,
in December 2013,
lordship,
every Friday
lordship,
on total 5 bigha,
lordship,
so and so less. Right.
lordship.
Now, during the course of those proceedings,
Lordship,
there were 2 proceedings.
lordship.
Another one was instituted by somebody,
Page
their rival, the so-called settlement holder.
Ajibur Rahman.
Huh. Now, come to page 27.
27, your lord.
Last para. By an order.
By an order dated so and so.
Read. Please read.
By an order dated 25/9/2014, passed in WPC 5089 of 2014, the learned government advocate was directed to obtain instruction as to whether Gauranagar Damri Bhasa Bridge Tiniali Pasuhat is operating on a private land or Panchayat government land. An affidavit was filed by the respondent number through the Extra Assistant Commissioner. And
Respondent number 3 was? Respondent number 3 was Deputy Commissioner. Right.
Extra Assistant Commissioner.
Deputy Commissioner.
That with regard to the statement made in paragraph 3 of the writ petition, deponent beg to state that Gaurnagar Damri Bhasa Bridge Tiniali Pasuhat in the name and style has established over the plot of private land
What you have
measuring
read? 1 minute.
28, your lordship.
Page 28. That with regard to statement. Yes.
Lords.
Yes.
That with regard to the statement made in paragraph 3 of the writ petition, the deponent beg to state that Gaurnagar Damri Bhasa Bridge Tiniali Pasuhat in the name and style has established over the plot of private land measuring 3 bigha 3 kotha 6 lesa of Miadi Patta number 541 covered by Dag number 1164 of village Damri Bhasa stands in the name of Abdul Mojid, son of so and so, and another plot of land in the same village measuring 2 bigha 1 kotha 0 kotha 1 lesa Miadi Patta so and so covered by Dag number so and so under Lakhipur Revenue Circle stands in the name of Adut Mullah and others. The total 5 bighah 3 kotha, 7 lecha over which the same market is running. As per LM Latmondal Kanangu's report, it is to be mentioned that the said Pasuhat is running over the private land owned by the petitioners and others, and co-patterners have given NOC through notary Gwalpara.
Okay, done.
Lordship.
Now let us see your case.
Now your lordship will kindly come to page 27, your lordship.
In your case,
Lordship. This was dated, your lordship, 1/12/2013. Minutes of general meeting, your lordship. Of the Gaon Panchayat, your lordship.
where is the evidence you are running?
Lordship will kindly first see
I have
this.
seen, I
Lordship.
have read.
Lordship. Lordship. And the market shall be situated at Goronagar, Damri Bhasa, bridge Tiniali on land belonging.
Where
to
is
the-
your description of your land?
Lordship will kindly see.
Where is that?
The market shall be situated at so and so on land belonging to the Meher Talukdar. And Meher
Which
Talukdar.
paragraph?
Lordship. Para 28, your lordship, page 28.
Hmm.
To mitigate these security risk and economic hardships, the assembly has unanimously resolved to establish the new Pasuhat. The market shall be situated at so and so on land
So
belonging.
when all these disputes
Lordship.
were continuing since
Lordship.
2014, where were you?
Lordship will kindly see, then Abdul Malik Talukdar, petitioner number 2, is the son of late Meher Talukdar, your lordship.
No,
That's
where
on whose
since
property?
when litigations were
Lordship.
continuing for this Damri Bhasa
Lordship.
since 2014,
Lordship.
where were you?
Your
Where is your existence in the litigation? I have seen all the repetitions.
lordship.
Or this Abdul Malik and Badut or whatever, these two were consistently
Lordship.
pursuing litigations.
Lordship.
Where were you, Mehek Talukdar?
That so far as that part is concerned, your lordship, then I will have to, your lordship, being some, take instruction, your lordship. If,
And as you know,
in fact,
at that point of time,
Lordship.
because of Rupam Talukdar,
Lordship,
there was no permission required,
lordship,
notwithstanding our Panchayat resolution.
lordship,
And Deputy Commissioner has clearly submitted before the court that 5 bighah so and so, Friday, this market is running
lordship,
on a plot of land of these two petitioners since December 2013.
lordship,
Right?
So
In
far
the
as-
earlier proceeding.
lordship. No, so far as this is concerned, your lordship,
I have not seen Mr. Mehek Talukdar.
no, your lordship, kindly see page 144, your lordship. আমার ইয়াত কোনটো আছে? Your lordship will kindly see, they have
No,
permitted.
your name emerges
Yes, lordship.
in 144. But how do you claim?
No, your lord.
You may be a new entrant.
No, that is your
But if
lordship.
it is so, Mr. Botago, it will be a very misrepresentation of you.
No, your lordship will, had this been the case, your lord, because your lordship, I am making a statement on oath that your lordship, I am running, and if it is not there, then it will be a misrepresentation of fact. There is no doubt about that, your lordship. I don't deny that. But your lordship,
But
on instruction,
where were you? Because this Abdul Mojid
lordship,
and Bodut,
lordship,
they were being interfered with,
lordship,
right?
Lordship.
By the authorities since 2014, time and again.
lordship,
They had to approach the court time and again,
lordship,
filing writ petitions.
lordship.
And if you are in the adjacent plot of land,
Lordship.
running a cattle market,
Lordship.
you are being spared. Are you a blue-eyed boy?
No, that is not, that is why your lordship on Sunday
So-
I have given.
No, Mr. Botago, this is not matching for me.
Lordship.
Maybe I am
Lord-
asking a wrong question.
No, no, your lordship.
You have emerged recently, no doubt. You have a plot of land, no doubt.
Lordship.
But how can you claim that since December 2013, you were operating a cattle market?
Since your lordship, a query has been put by your lordship, it is my duty to take instruction. I will come back to your lordship.
Because I am finding it something strange. Miss Chaudhary, can you support?
Lordship.
Are they operating cattle market?
No, no. We have taken lease of their lands to extend our market. Lord. For some period, lordship. Later on, that was given.
But ultimately, the deputy commissioner's finding is 5 bighah so and so.
Yes, that is our letter.
Yes, Mr. What do you want to highlight?
My lord, Lordship already taken that point, my lord, because they both petitioners are claiming the same market.
Huh.
Name of the markets are.
You are saying that this market I am running.
Lord,
Your
Lord.
case.
No, my case is that along with them, Your Lordship, I am also running.
Where is that?
Lord. Para 3, Your Lordship, may kindly see. That this
But
so
that
and
is
so
not-
was
If
originally
that is so,
Lordship.
how come in 2014 all this came and you were not there?
No, Your Lordship, that thing, to that extent, I will have to take instruction, Your Lordship. But Your Lordship, that specific statement is there at
But
Para 3.
if you have come recently
Lordship.
to run a cattle market
Lordship.
and submitted an application
Lord.
and you were allowed to run on what day?
Sunday, Your Lordship.
That is fine.
Lordship.
But your claim since 2013,
Lordship.
that is not very convincing for
Lordship.
me as on date. As on date.
There is no material, Your Lordship.
As on date.
Lordship.
Right. And do you have any approval?
No, Your Lordship, that apart from that, Your Lordship, the state government approval is not there.
Not there.
Not there.
And Gaon Panchayat approval?
Yes, that is, Your Lordship, this
Which one?
latest
Oh,
one.
this one.
Lordship. And Your Lordship will. It took it here.
April 15.
You have to clarify, Mr.
Lordship, I will clarify, Your Lordship.
Otherwise,
There is a one document
this is to be, unless you don't clarify and you claim on the basis of that, code would come harsh.
In fact, Your
And
Lordship, it is
Do you
there.
have any to say?
Some documents are there, Your Lordship.
That is what is already pointed out. With respect to the same market, he is also claiming to be the secretary. The other one is also claiming to the secretary. So we do not know who is the secretary, who is the land.
As on date, item number 3, that is Abdul Majid, they have materials to show. They are pursuing litigation since 2014.
Yeah, litigation they are
Yes.
pursuing.
And,
Litigation they are
and
pursuing.
Deputy Commissioner has endorsed.
That has been set aside long back.
No.
I will show from the affidavit in opposition.
Madam, don't say that. That has not been said.
Opposition, I will
No,
show.
That is the affidavit in opposition of 2014. Don't say that.
In my present affidavit in opposition.
No,
I
you
will-
cannot deny after that.
No, I'm not denying
Come to
that.
page 28 of the first petition. Don't make submission to confuse the court.
I'm sorry, my.
I have been confused already, but I have come
I am sorry, my.
right now.
My lord.
I have understood the situation.
Page 28.
Heard Mr. Amish R. Chaudhary, learned counsel for the petition. Mr. S. Dottola and Standing Council, Panchayat and Rural Development Department for the response number 1, 3, 5, and 8. Mr. Bothagur, I am seriously asking you.
Lordship. Sir.
And Mr. S.R. Burua, Learned Junior Government Advocate, Assam for the response number 2467. And Ms. P. Goel, Learned Counsel for the response number 9. Ms. Goel has submitted that an affidavit on behalf of the response number 9 has been filed and the same is not on record. Full stop. Para. Mr. Dotto has submitted that he has not yet received instruction as regards the basis of allotment. Full stop. Para. It has been brought to the notice of the court that by the judgment, an order dated 19/12/2025 passed in WBC number 7390/2025, the additional Chief Secretary to the Government of Assam, Panchayat and Rural Development Department was directed to dispose of the representation submitted by the petitioners seeking 45, 5. To give consideration, whether the application submitted by the petitioners on 22/8/2024 under section 107 of the Assam Panchayat Act, as amended, seeking approval to run the private market can be granted approval or not within a period of 30 days from the date a certified from the date of submission of the certified copy. First off, Ms. Chaudhary, when it was submitted?
2020.
Ms. Chaudhary has submitted that the certified copy of the judgment and order dated so and so was submitted before the additional chief secretary to the government of Assam Panchayat and Rural Development Department on 20.
25, page 94.
Good. First off, as more than August, September, October? No. Okay, as about 3 years, as 3 months have elapsed. Mr. Bhattakur shall also, or Mr. Datta shall also obtain instruction as to whether the application for approval has been given consideration or not. Both issue notice returnable on short video. After definitely election, 22nd April, as so and so has appeared accepted. No formal notice, extra copies. Spera. You are operating some market. You are operating.
Yes, my lord, illegally they are doing it.
Whatever. The parties shall maintain status quo as obtaining today. The next date of listing. Status quo as regards operation of cattle markets as obtaining today till the next date of listing.
I'm grateful.
My next, Mr. Bhattakur. Hired Mr. S. Bhattakur, Learned Counsel, the petitioner.
One document, your lordship may peruse, your lordship, that page 85, your lordship. It gives your lordship some idea, your lordship, but not the exactly that from then onwards we are running, but it says, your lordship, this is the peruse the resolution, this is a meeting of so and so.
I have seen Mr. Bhattakur, all these documents also page 72, all licenses.
Lords.
Still, I am not convinced.
Lords.
Reduce the. Okay, we'll bring the records of this.
Lords. And in the meantime, I will also, your lordship, file additional affidavit, your lordship. If what has been instructed to us is correct, your lordship.
Requesting to resume and run. What I am finding it strange that
Lordship, in the entire
authorities are
proceedings,
interfering with
I was not-
with the petitioners in Ms. Chaudhary's case, and you are allowed to run smoothly.
Lord.
That is very doubtful
Lord.
case.
I will try, your lordship. Because your lordship, I am filing this
Ms.
petition. your
Chaudhary have
lordship.
been pursuing litigation since 2014. It looks like you are like Heli petitioners as Dr. Learned Standing Council, Panchayat and Rural Development Department for the respondent number. All the respondents, full stop. We'll simply issue notice. Issue notice, returnable sale, so extra copies.
My lord, in this case, my lord, the elected body has not been served a copy. Let a copy.
Notice
be
has not
served
yet been
upon us
issued.
also.
Who is
Yeah,
the elected body?
Today notice is issued.
You elected body?
I'm the elected, yeah, I'm.
Not
the
a
elected
respondent.
body. That's what, my lord, they are, but they are,
You implicate yourself.
my lord, they are seeking relief from me only.
No,
That
it's
I have-
secretary. Gaon Panchayat secretary has been made party.
That's right. That's correct.
You raise your voice through.
Grateful, my.
Mr. Bothakur.
Both will be taxed.
Council for the petitioner shall apprise this court about the claim of the petitioners. Apprise this court with documentary support about the claim of the petitioner that the petitioners were running a cattle market from their periodic patta lands since December 2013.
I'm obliged.
2204. Item number 6.
I am before your lordship against the award passed by the.
Right.
I am for the management. My only ground is jurisdictional ground. That the labor code could not have gone into.
But you continue 17B.
My lord.
On the previous date, I asked Mr. Chakraborty to apprise this court
Yes,
about 17B compliance.
yes. That is, my lord.
Heard on that will be decided on a later. Heard Mr. H. Aforesaid, learned counsel for the petitioner. Mr. Borua, you were there?
I am for 1 and 2.
Mr. S.R. Borua, learned junior government advocate Assam, the respondent number 1 and 2. Close up. The petitioner. In this petition, under Article 226 of the Constitution, the petition has assailed. Where is the page?
My lord, award 128.
Page?
128.
An award dated 15/11/2025, passed by the Labor Court,
Presiding officer labor.
Assam, Kamrup, in reference case number 07/2024. Posted by the award, the learned labor court. In the award, has held that the respondent number 4 workman has been illegally retrenched from his service. And the Labor Court has directed for reinstatement of the respondent number 4 workman and to pay him full back wages with other monetary benefits as per his entitlement from the date of his termination within a period of 2 months from the date of passing of the award. Additionally, in addition, the petitioner has been directed to pay compensation amount of rupees 1,50,000 towards grant for illegal termination of the workman. Full stop. Issue notice returnable on so and so. As Mr. Borua, 1 and 2. No formal notice. Extra copies 2 working days. There is no necessity to issue any notice to the respondent number 3. Full stop. The petitioner shall take steps for service of notice among the respondent number 4 by speed post within 2 working days from today. Before that, the case records of reference case number so and so be requisitioned.
Operation of the award may be stayed. Operation of the.
I asked few questions to Mr. Chakraborty on that day.
Fine.
Right? And to come up with the answer.
I have the answer.
Please tell.
Did
Did you lead evidence?
Yes, yes.
Did you lead evidence?
In the cross-examination, I put a specific question. He denied. But that question was put in the cross-examination.
Did you lead this documentary evidence which you have brought in this writ petition?
So regarding the appointment letter, there is no doubt that appointment
No,
letter
no,
itself
I have-
shows.
my question is, did you bring the documents which you have annexed with the writ petition before the labor court?
Yes, yes.
Let us see.
My lord.
I have traveled once
My lord.
with Mr. Chakraborty,
My lord.
right? Now I am going to travel again.
My lord, page 39.
Now come to the award.
Award, my lord.
Which paragraph?
No, in the award, that part is.
Mr. Don't
Yes. Yes,
waste
yes.
time.
But that was.
The matter of interim, the interim prayer is kept open for consideration on the returnable date.
2404.
But then, my lord, they will go for they will go for.
Otherwise, I'll expressly say that 17B is made operative. Let him come.
Madam.
I will ask question to him
Madam.
whether he is gainfully employed somewhere.
Yes, yes, I have the document.
No,
But that
your
is not-
document will not say.
Yes. Yes. All right.
Item number 7.
Yes, Mr. Somoria.
Please appearing on behalf of someone.
Any instruction?
No, Lordship, I have still waiting.
Then, Mr. Must to issue notice.
My lord.
At your instance, I have placed it.
Well, Lord, one similar matter listed before in another bench, which has been fixed on Monday. So it may be also fixed on Monday. We'll.
My lord, I want to submit something, my lord. Because, my lord, your lordship kindly go to the para 49 of my writ petition, my lord.
Para?
Para 49, page 49. Para 3 and 4.
No, Mr. Chaudhary, unless there is admission, how can we?
If we take the instruction, my lord.
He can take
I am
We'll,
no problem.
we'll try on Monday, Lord.
I have no problem.
Third, Mr. NNB Chaudhary, learned counsel for the Prohibitions, and Mr.
MM Zaman, Lordship.
MM Jaman, learned counsel on behalf of Mr. S. Somoria, learned standing counsel of Corporation Limited. For the response number 4, 5, 8, and 9, post of Mr. Jaman has sought for listing of the case on next Monday in order to obtain instruction as regards the claim of the petitioners for an amount of rupees 7,08,896.
Hello.
2303.
Okay, we come back just.
Daily list item number 8.
Made pleasure, lordship. Lord, Oil India Limited granted a contract, my lord, to the petitioner. This is, my lord, commissioning of 2 numbers of track-mounted hydraulic wireline winches. And my lord, it's a very technical term. And the award was given for a sum of rupees, my lord, 13.73 crore. My lord, about 70% of the work I have completed. But in the meantime, my lord, my contract has been terminated, I have been blacklisted, and my bank guarantee has been forfeited. And before your lordships. Now, my lord, first come first, there was an FIR lodged by my lord CBI. That your lordships will get at page number 68. I'll just read the first 2 paragraph, my lord. These are the allegation.
Yes.
Source information has revealed that Prayat Chakraborty, Deputy General Manager, Oil India,
in connivance with Jyoti Kumar Singh, DGM, this the Milord is an officer of the petitioner company of United Drilling Tools Limited, Noida, and unknown public servants are indulging in corrupt and illegal activities of obtaining bribe money against facilitating issuance of award of work and clearance of bills of the said private contractor supplier, thereby causing wrongful gains to themselves and corresponding loss to the union exchequer. Such source information has further revealed that on 16/4/25, Prayat Chakraborty again demanded 70 grams of gold ornaments for himself as well as for some other unknown public servant from Jyoti Kumar Singh against award of certain contract in favor of him, and Jyoti Kumar Singh also agreed to the demand. So this is the allegation, my lord. Therefore, a case under 61(2) of the BNS, read with section 7, 9, 10 and 12 of the PC Act was registered. Incidentally, my lord, Prayat Chakraborty and the Jyoti Kumar Singh, they were arrested, my lord, and they were released on bail. And bail orders would also reveal, my lord, there is nothing. Now, what had happened, my lord? In the following, my lord, completion of the investigation, a charge sheet and a supplementary charge sheet was filed. Now, I'll have your lordship's kind attention to the supplementary charge sheet, my lord, which your lordships will get at page number 73. I'll have your lordship's kind attention to 75. Para 16.6 and 16.7. During the course of further investigation, apart from tender purchase order dated so and so, other tenders which were allotted to UDTL, that is the petitioner company, by All India Limited during 20 to 25 have also been scrutinized. Further investigation has revealed that accused Prayat Chakraborty was not associated with the said tender purchase order, as he was on deputation in Directorate General of Hydrocarbon, Noida from 7/24. During further investigation, no association of Prayat Chakraborty has been found with any other tender allotted to Mr. UDTL by oil since 2020, except purchase order dated so and so. During the course of further investigation, no irregularity could be found in the allotment of tender to UDTL. Further, it is revealed that payment have been made to the vendor, Mr. UDTL, after receipt of material. All materials have been found received and duly recorded in the goods received notes. No criminal involvement of other officials of oil could be revealed in the allotment of tender bearing number so and so. And no evidence could be found which show that other employees of UDTL, that is petitioner, was also involved in bribing Prayat Chakraborty and other employees of the oil for tender purpose orders awarded to so and so. Now, my lord, the charge sheet clearly says that neither Mr. Singh nor Chakraborty is involved. Now, please come to the show cause notice.
Against whom charge sheet was submitted?
My lord, some others. As far as the present petitioner company's employees and Prayat Chakraborty is concerned, who are involved in this case, they were found to be, my lord, not involved. And all have been given clean sheet. No? Now, my lord, will kindly come to the show cause notice. Show cause notice which was issued by the authority, my lord. It is at page 112. It is entirely based on the FIR. They have invoked, my lord, clause 2.1 of the integrity clause.
24, 25.
Now, you are required, has your lordship got it, my lord?
Page?
Page 112, 29/7/25. You are hereby required to show cause in writing within 15 days from the date of issuance of this notice as to why your company, namely United Drilling Tools, should not be put on holiday list of All India Limited and debarred from carrying out the business with oil for the following reasons. That it has been reported, alleged that about the commission of corruption by Messrs. United Drill Tool Limited, including two officials of a company in collusion with an officer of the oil while dealing executing orders in Oil India Limited. In this regard, Oil India has received a letter bearing reference dated 4/5/25 along with the copy of the first information report, the one which I have read, stating about arrest of one officer from oil. The FIR pertains to the alleged offence of corruption and bribery of public servant by private person and commercial organization in criminal conspiracy. So, my lord, the FIR is based on the police report and the FIR. Am I clear, my lord?
When the supplementary charge sheet was submitted?
Yes. 22, no, 1 second, my lord. 22/12/25.
There was a prior charge sheet.
Maybe, my lord, there was some prior intimation, communication from the
So this is
TBI.
supplementary, the
Yes.
the previous one?
No, my lord, the previous one, there is nothing, my lord. We have not brought on record. In the previous one, there is nothing against us. Now, my lord will kindly see what are the burning policy of the oil and how the actions are to be taken. But now, first of all, if your lordships would kindly come to the banning policy, which your lordships will get. Please come to me, Lord. Banning policy at page number 37. Now, page 36, my lord. And 4.1, an agency can be considered for debarment if it is determined that the bidder has breached the code of integrity as per Rule 175 of the General Financial Rule 2017. Now, my lord, will kindly come to page number 62, my lord. 61. This is the Integrity Pact. That's why it's. Please come to page 61, my lord. They have invoked this clause. The bidder contractor commits itself to take all measures necessary to prevent corruption. He commits himself to observe the following principles during his participation in the tender process and during contract execution. Bidder will not directly or through any person or firm offer, promise, or give to any of the principal employees involved in the tender process or the execution of a contract or to any third person any material or immaterial benefit which he is not legally entitled to in order to obtain in exchange of any advantage of any kind whatsoever during the tender process and during execution of the contract. Now, Lordship has noticed from the show cause notice that it is essentially under this clause, clause 2.1. Why they say so? There they rely upon the FIR. What is the FIR all about? FIR says that two officials of the petitioner company bribed Parag Chakraborty to get the job. Now, following investigation, my lord, that has been proved to be wrong. So, my lord, that allegation absolutely goes. Now, my lord will kindly come to the GFR part. Page number, first, my lord will kindly come to page number 49. My lord, I'll satisfy your lordships. It's a, my lord, open and shut case. An absolute abuse of the authority. Page 49. Rule 151, debarment from bidding. A bidder shall be debarred if he has been convicted of an offence. Merely because an FIR has been lodged, I cannot be debarred. The company cannot be debarred. It is only when there is a conviction, my lord, the consequence of debarment can ensue, not otherwise. Then, my lord will kindly come to 175. 175-2,
170.
page 52, my lord. The procuring entity, after giving a reasonable opportunity of being heard, comes to the conclusion that
175?
2, my lord, at page number 52.
Okay. 170, okay. Hmm.
The
Yes.
procuring entity, after giving a reasonable opportunity of being heard, comes to conclusion that bidder or prospective bidder, as the case may be, has contravened the code of integrity, may take appropriate measure. So, my lord, not only, my lord, the GFR and the banning policy lays down how and in what manner a show cause notice is to be given, it also lays down the manner in which the decision is to be taken. In the instant case, my lord, there was no, my lord, hearing was given to us. We filed a reply. We wanted to file a detailed reply, my lord, which was denied, and they passed the order. Now, my lord, what they have done, they have passed 3 orders. First, lordships will have 246. In fact, the order starts at page 243, my lord. This is the banning order, and the operative portion is at page number 246. No hearing was given to me. Thus, somewhere in the middle of page 246, the undersigned, after application of his mind and wisdom, and after having gone through the entire matter and documents on record, and submissions made by UDTL with respect to oil show cause notice, it is established that Messrs. United Drilling Tools Limited has defaulted the contract provision by violating the provisions of the Integrity Pact. Now, therefore, the undersigned, after application of mind and considering all aspects of the oils banning policy, hereby orders that United Drilling Tools and their allied firms are placed under holiday list of Oil India, and thereby debarring them from participating against oil's future tenders for a period of 2 years with effect from 29/7/25. Secondly, my lord, they have cancelled my contract, which is in the next page. 264. The award which was awarded on 3/3/25, my lord, that has been cancelled. At page 264, 1.1, with reference to the above, Oil India Limited has decided to cancel GM contract dated 3/3/2005. Then, my lord, at page number 268, our bank guarantee has been, my lord, invoked. At page 268. Contractor has failed to comply with terms and conditions of contract. You are therefore requested to remit the bank guarantee amount. So, my lord, they have instructed the bank, and bank has, my lord, revoked it, invoked it. Now, my humble submission is, my lord, it's a clear, open and shut case. The action was initiated on the basis of an FIR. And, my lord, most importantly,
Whether in the impugn order, it
Yes,
has
ma'am.
taken note of the charge sheet.
no. No. They in fact rely upon the FIR, my lord. No, headed to 243. Nowhere, my lord. Supplementary charge sheet to Tariki Manis. My lord, supplementary charge sheet is later in point of time.
Supplementary charge sheet later in point of
Later
time.
in. Because the order is 1010 and the supplementary charge sheet was 2212. My lord,
Some charge sheet is mentioned here.
Yes.
To page 45.
Yes.
Court
245.
order 14/8/2025. 14/8/2000.
On 245 top, my lord.
No,
FIR has now been registered as criminal so-and-so in the court of so-and-so, verified order dated has taken cognizance has been taken.
No, next part.
So-and-so, as amended against the accused person named in the charge sheet. No, Miller.
No, it is there.
Has taken cognizance of the offence under section 61(2) of the Bharatiya Nyaya Sanhita, so-and-so, against the accused persons named in the charge sheet, including the company.
14
It has taken note of the cognizance. But, my lord, as the lordship has seen from the supplementary charge sheet, my lord, we have been given a clean sheet. And now the most importantly, that officer has been reinstated in service. Prayat Chakraborty has been reinstated. When Prayat Chakraborty has been reinstated, why should we suffer this, my lord, disqualification now? And prima facie, my lord, until and unless the allegations are proved, I can appreciate, my lord, in an appropriate case, one may keeps the registration under suspension or something. But where is the question of banning? And where is the hearing, my lord? My lord, I'll rely on the one judgment of the Supreme Court, my lord. Before that, my lord, I'll just point out, a tender was issued on 11/8/25, in which I was not allowed to participate, my lord. So my humble submission at this stage is, my lord, at least my banning part should be stayed, my lord. Others, lordship may take a call after they file the affidavit, my lord, so that I can go on with my business, my lord. Otherwise, it will be very harsh, my lord. It is absolutely disproportionate, judgment to the.
One search it was Mr. Chaudhary.
Yes.
71.
Page 71, my lord.
One search it was 27/6/2025.
Yes.
There, your names appeared.
But subsequently not, my lord.
Right. That is what bit contrary to each other.
Yes.
Supplementary charge sheet also has been read in a different context. I will read it in a different context. I'll show you also.
Okay.
Okay, what is the judgment?
Now, my lord, yes. My lord, I'll rely upon 2014-14 SCC 731. Understand?
That is the name?
No, I'm handing over the copy, my lord. Paragraph 17.
Which contract? New tender? Which new tender?
Yes, my lord. Page number 269, my lord. Earlier it was 2 numbers, now it is 4 number. Lord, it's a vehicle mounted with all those drilling stuffs, my lord.
Okay, let us have this first confusion regarding.
One more thing, my lord. As far as the, my lord, if first charge sheet and second sheet is, or whatever it is, my lord, these are all matters of record. I cannot improve it. The fact of the matter is, my lord, the supplementary charge sheet says there is absolutely nothing.
Right. That
And
is what.
secondly, most importantly, my lord, they are bound to give us a hearing. If a hearing could have given to us, we could have persuaded them to take a different view. And we have been prejudiced on account of that. Because they cannot take a decision without hearing me. We are merely on the basis of the spoken reply. And I could have explained this position.
Yes.
But there are ultimately two issues with your lordships. Number one is whether
the source of information by way of that FIR and the subsequent charge sheet and the supplementary charge sheet contains any information or contains any evidence against them for the trial court to proceed. And therefore, that can be a relevant material for us to also start or initiate our process for the banning process. Because as has been submitted, that is the source or that is the basis. And that is correct, Lordship. Now, if your Lordship will first see the FIR first. Regarding the personal hearing, I'll come to that. Personal hearing was something that they did not avail finally. Now, I'll just place that. But first, if your Lordship will come to page 68, the FIR. The first two paragraphs already my learned senior friend has read. I'll read from the paragraph number 3. Source information also reveals that on 18/4/2025, Sri Jyoti Kumar Singh conveyed to Sri Prayas Chakrabarti that he had taken the approval of his managing director, Sri Kunal Gupta, for a bribe of rupees 7 lakhs. Sri Prayas Chakrabarti reminded him that he had not asked for cash and once again demanded delivery of 70 grams of gold coin instead. Sri Jyoti Singh told him that due to some reason he won't be able to purchase gold and therefore he will be delivering 7 lakhs in cash instead. Source information exists that on 3/5/2025 evening, Sri Jyoti Kumar Singh would be delivering certain cash amount as bribe instead of gold to Sri Prayas Chakrabarti near Noida sector so-and-so, which is also close to the residence of Prayas Chakrabarti. Now, based on this information, the CBI had registered this case. Now, if your Lordship will come.
So after registration of this case,
Yes, Lordship.
because say 3/5/2025,
Yes, Lordship.
that delivery would be made.
Yes, Lordship.
So was there any trap proceeding?
No, the trap proceeding was not there. No,
Not
the trap
there.
proceeding was not there. But telephonic discussions are there, which forms a part of the charge sheet.
Maybe.
Yes. Yes, that is something the trial court will look
It
into.
would been a trap, it would have been a
That is a very clear case.
assume different proportions.
True,
But
Lordship. That
here it is on the basis of this, but no trap.
basis of this, and this is basically based on telephonic discussions.
No trap proceedings so far.
No trap proceedings. Admitted, no trap proceedings. That is, in fact, the ground taken by the court for giving them bail also, Lordship.
Yes.
Now, if your Lordship will come to page 71,
Yes.
there is a charge sheet. There is
Right.
a charge sheet dated 27/6/2025. It has not been brought on record by the petitioner, but the cognizance order at page 71 clearly indicates to the fact that they have been found that there are materials against them and they have been found to be charged accused. If I may read that order, page 71. Dated 14/2025. Also got that? Charge sheet dated 27/6/2025 has been submitted by Mr. Suraj Pal, Inspector of Police, so-and-so, against the accused Prayas Chakrabarti, Jyoti Kumar Singh, and Kunal Gupta. Jyoti Kumar Singh is the DGM sales, and Kunal Gupta is the managing director of this petitioner company. For the United Drilling Company, the petitioner, through his authorized representative, so-and-so. I have heard so-and-so. Now, on the perusal of record, it reveals that the accused Prayas Chakrabarti, Jyoti Kumar Singh, and Kunal Gupta had entered into a criminal conspiracy and agreed to perform illegal act by corrupt practice. Prayas Chakrabarti, while working as a public servant, has demanded performing his public duty improperly and dishonestly, while being posted as the Deputy General Manager, Material Oil. Whole-time Kunal Gupta, whole-time Director, Managing Director, Jyoti Kumar Singh, General Manager, Sales of UDTL, had agreed and paid undue advantage to Prayas Chakrabarti with the intention to obtain and grow business of their company, UDTL with oil. For taking cognizance of the offence against accused Prayas Chakrabarti, Jyoti Kumar Singh, Kunal Gupta, United Drilling Tools Limited, through its authorized representative so-and-so, for offences punishable under Section 61 BNS and Section so-and-so of the PC Act and substantive offence thereof, sufficient materials is available on record. If you also will see the second paragraph of page 72, the last line. Page 72, the last line. For taking cognizance of the offence against the accused. Accused are our employees there, as well as the DGM sales, who is Mr. Jyoti Kumar Singh, Kunal Gupta, who is the MD of the company. The court has said sufficient material is available on record. Prosecution sanction under Section 19 PC Act has been received against the public servant. Accused persons, namely so-and-so, so-and-so. Accordingly, cognizance is taken 61(2) of the BNS Act, Section so-and-so, so-and-so. Therefore, against the accused persons, namely Prayas Chakrabarti, Jyoti Kumar Singh, Kunal Gupta, United Drillings, Toria so and so, so and so. CBI is directed to provide copies of the police report and other documents to all the accused persons for compliance of section 207 of the CRPC, along with list of unrelied documents and statements. File be registered as a sessions case. Now, therefore, what is indicated from this cognizance order is that materials were available, cognizance have been taken, and a proceeding for trial has been initiated. Now, if your lordship will come to the supplementary charge sheet. The reading of the supplementary charge sheet has been such made that they have been completely absolved from the offense, but it is not so. If I read it properly, lordship will see what was the context of that supplementary charge sheet. Page 73. Now I take your lordship to page 75. Result of further investigation. This is further investigation. Now, what was the scope of this further investigation? If I read, lordship will find out. 16.5. That after investigation, a charge sheet dated 27/6/2025 was filed before this honorable court against the 4 accused persons, so and so, so and so, so and so. The further investigation of this case was also kept open to ascertain the role of other officers of oil, UDTL, in the instances of bribe of this case, as well as in other tenders allotted to UDTL. So the scope of that particular investigation was to see whether other employees, as well as across other contracts and tenders, was where these kind of product activities have taken place or not. And then it starts thereafter. During the course of
Just. Yes.
page 75, Lordship. I was on page 75. What I was stating is that the scope of that investigation, which is a part of the supplementary charge sheet, is to look as to whether other employees of the oil and the petitioner company across other tenders, also these kind of offenses of bribe have taken place. So therein now the charge sheet says 16.6. During the course of further investigation, apart, Lordship will mark the word apart from the tender purchase order, so and so dated 3/3/25. This is the concerned contract we are talking about, Lordship, 3/3/25. Other tenders which were allotted to UDTL by Oil India Limited, Duliazan, from the period 2020-2025 has also been scrutinized. Further investigations has revealed that accused Prayas Chakraborty was not associated with the said tenders, purchase orders, as he was on deputation in the Director of Hydrocarbons from 17 to 2024. During further investigation, no association of Prayas Chakraborty has been found with any other tender allotted to UDTL by oil since 2020, except the purchase order number so and so dated 3/3/2025. So the scope or the context was regarding the other tenders, not regarding this tender.
The next slide.
During the course of further investigation, no irregularity could be found in the allotment of tenders to UDTL. Fine. So what the charge sheet says, for allotment, there is no irregularity. Further, it is revealed that payments has been made to the tender vendor UDTL after receipt of materials. All materials have been found received and duly recorded in the goods received notes. No criminal involvement of other officers of oil could be revealed in allotment of the tender number so and so dated so and so. No evidence could be found which shows that other employees of UDTL was also involved in the bribing to Prayas Chakraborty and other employees of oil in other tenders, purchase orders awarded to UDTL. So this paragraph 16.7 has two parts. One, they are saying that during our investigation, we have found that for this particular tender itself or contract itself, during allotment, there has been no irregularity found. During the clearing of the bills, no irregularity found. But it also says that apart the other contracts, no irregularity found. But regarding this issue of bribing, they have said that there is material regarding this bribing. They are saying that exclusive. Exclusive to the other tenders, they are saying that in those tenders, we have not found anything. In this tender also, regarding the allotment of the tender, regarding the payment of bills, we have not found anything. But regarding the bribing aspect, there are materials. Now, why they say there are materials? 16.8. Let's see, we'll see 16.8 kindly. On what basis they have come to this finding that there are materials regarding the offense of bribing? 16.8. During the course of further investigation, the mobile phones, electronic devices were sent to CFSL, Central Forensic Science Laboratory, for retrieval imaging of data which has been received from CFSL. The data which has been retrieved from the said phones, electronic devices, nothing could be found which shows that other employees of UDTL was also involved in the bribing of Praya Chakrabarti and other employees for other tenders, orders, award to UDTL. So the entire context and the scope. Yes, I'm reading. The CFSL report regarding examination of voice samples of the accused person, Sri Praya Chakrabarti, Jyoti Kumar Singh, Kunal Gupta, taken during the course of investigation is awaited, and the same will be filed before the Honorable Court on receipt. The original documents and statements of witnesses recorded have already been filed by so and so and so. It is therefore prayed that the supplementary final report will be taken on record by this Honorable Court. So therefore, it could be indicated that there are telephonic evidences, telephonic records, which has been sent to the CFSL, which are those reports are awaited. Now, I do not know the exact position of what is the position till date because this is of December 2024. So therefore, the statement that they have been found to be given clean sheet, in my humble submission, is not correct, Your Lordship. The charge sheet remains, cognizance have been taken against them, they have been found to be charged accused, and a trial proceeding is going on.
Now,
Yes, Lordship.
come to your banning policy.
Yes, Lordship. So this is one aspect. And now regarding the...
Page 36.
Yes, Lordship.
Uh, 4.0.
4.0. Yes, Your Lordship.
Please read 4.1.
Yes. An agency can be considered for debarment if it is determined that the bidder has breached the code of integrity as per Rule 175 or the General
What is
Penance.
the meaning of determined?
The test, Lordship. There has to be a test to determine.
Determine is related to determination.
Determination, yes. There has to be a test of determination. and that is
175. Let us see 175.
175, Lordship will find at page 40, page 51, Lordship. Okay. 51 speaks about the instances under which will be contravention, Lordship, of the code.
Page 52, 175.
Yes. Rule 175.2. The Lordship is referring to that, 175.2.
No visual of procuring address shall act in contravention includes 175.2.
We are proceeding in terms of 4.1.1 Roman 1A. 4.1.1 Roman 1A. Page 36 only. Prohibition of.
Containing A.
Yes, Your Lordship. Making offer, solicitation, or acceptance of bribe, reward, or gift, or any material benefit, either directly or indirectly, in exchange of an unfair advantage in the procurement process or to otherwise influence the procurement process. Before that, if I may take you, Lordship, to the Integrity Pact, page 61. I'll just place the entire process or the sequence as to how Oil India has proceeded. Page 61. This is Lordship, page 61.
Sixty-one.
61, Your Lordship. There is no dispute that the integrity pact, a signed integrity pact, exists between the petitioner and the respondent. Now, if Your Lordship will come to section 2. Well, another senior has already read that, but I'm just reading it for cost of repetition, Lordship. Section 2, commitment of the bidder contractor. 2.1. The bidder contractor commits itself to take all necessary to take measures necessary to prevent corruption. He commits himself to observe the following principles during the participation tender process and during the contract execution. Roman 1. The bidder contractor will not directly or through any other person or firm offer, promise, or give to any of the principal employees involved in the tender process or the execution of the contract, or to any third person any material or immaterial benefits which he is not legally entitled to, in order to obtain in exchange of any advantage of any kind whatsoever during the tender process or during the execution of the contract. Now thereafter,
Yes.
yes, Lordship. Now, Lordship has seen section 2.1 Roman 1 is the transgression. Now, therefore, where is the power to Oil India in the event of a transgression? That your Lordship will find at section 3.1. There is a transgression. Now, what Oil India can do? That is section 3.1. May I read, Lordship? If the bidder contractor has committed a transgression through a violation of section 2, such as to put his reliability or credibility into question, the principal is entitled also to exclude the bidder contractor from future contract award processes. So this is where the route for us as to what to do if a transgression is there. We have the authority or the power to exclude him from further or future contract and award. Now, to do that, we have a guideline, and that is the banning policy. So now, therefore, if I may come to the banning policy, Your Lordship. First, there has to be a transgression in the integrity pact that provides us the authority or the power to initiate a proceeding.
Which one?
Lordship?
Which one?
Integrity pact. Lordship is referring to integrity pact.
No, integrated not. You were referring to which page?
I was referring to page 61. Page 61. First, I referred to the transgression or the violation. And then I referred to section 3, the next page 62.
Oh, where is the provision for debarment in the banning policy?
Yes, Lordship. Now, if your Lordship will come to the banning policy, page 36, Lordship has seen, we have invoked this clause. Now, if your Lordship will come to clause page 39. Page 39, clause 5.1. Page 39. Page 39, clause 5.1. Subrule 2. The irregularities are prima facie established after award of contract then. during the execution of contract, if the contractor is found to have erred, defaulted any of the provisions mentioned in paragraph 4.1 and 4.2 in respect of the ongoing contract, the contractor shall put on banning debarment list of oil after following the due process.
Action against in respect of an ongoing tender.
Heading is clause 5, and the concerned relevant clause is 5.1, Roman 2, A, small a. It says if there is a default of para 4.1, then we may proceed for banning. Lordship, I'll also refer to the last line. The last line after following. Got that? What you seen that? After following. After following the due process, the order contract where it has been concluded that irregularities have been committed shall be terminated. So regarding the second power or the second issue of termination of that contract, because first there was a banning. The impugn orders are, number one is a banning order and number two is the termination of the contract. So I'm just showing this so that I do not come to
So
it.
that is what I am asking.
Yes, Lordship.
Page 39.
Yes, Lordship.
Now, say, let us, two officials, first Sarsi
Yes, Lordship.
and company, they have been Sarsi.
Yes, Lordship.
So that is irregularities are prima facie established.
Yes, Lordship.
Say, let us
Yes, yes.
take the position.
Yes.
Then, if now you are taking to last paragraph after following.
This is regarding the
No,
promotional
no,
tender.
1 minute. After following due process, let us read again. The irregularities are prima facie established after award of the contract. Let us
Yes.
say with a sarsit prima facie established.
Yes.
Then A, during execution of the contract,
If
if the contractor is found to have
are
erred,
defaulted in any of the provisions above in para 4.1. 4.1, Lordship has seen
I have seen.
that regarding bribe
Right.
and influence.
Right.
In respect of the ongoing contract,
Ah,
such contractor shall be put on banning debarment list of oil after following the due process.
right. Debarment list.
Debarment list. That's
Next,
what has
next,
happened here.
Next.
The next paragraph? Or the last line? The concerned contract order where irregularities have been committed shall be suspended forthwith by the engineer in charge who is supervising. This is regarding the suspension, Lordship. During that time, he will suspend it.
Suspended.
Yes, that is now over, that part.
Now,
The
third line.
third line. After following the due process, the order contract where it has been concluded that the irregularities have been committed shall be terminated.
So,
So this
where
is the
it has
second
been
part.
concluded,
Yes, concluded, have been
the
concluded.
irregularities have been committed. First one is prima facie established.
Then banning,
Banning.
because banning took place on 10-10.
Suspension of the contract.
Suspension, first suspension was there.
First, after following due process, banning or debarment.
Yes.
Right? Then suspension of the contract.
No, suspension will happen in the meantime. Because on 2-7.
Then termination is after concluded.
After concluded, yes. So what has happened here?
Trial has to be concluded.
No. Concluded is regarding our banning. The process of banning in our banning policy. This is what it refers to. It does not refer to a parallel criminal court proceeding, Lordship.
Okay.
Because Lordship will appreciate the situation. A trial will continue for 5-6 years.
I don't know what is the first charge sheet.
First it has not been placed on record. So therefore, I have to place reliance on the cognizance report itself. The cognizance report clearly indicates that they have been found to be charged.
And this is the 3/3/2025 is the order.
Yes.
That's the contract.
Contract.
So banning was on 10-10.
Second charge sheet indicates in no other contract, this man and these two men, except.
Yes.
So far 3/3/2025, there is prima facie established.
No, my lord, no, that is also, end of the day, it is not there. No, my lord, we are not disputing the powers, the manner in which the power has been exercised. For example, my lord, Lordship has rightly put the question at page number 39. Now, first we are at the banning. How banning will be done? As per GFR 175. What the GFR 175 says? A hearing has to be given. Where is the hearing given, my lord?
They did not.
Then, my lord,
Hearing not given.
not given, my
I will
lord.
place that. Why? I'll produce that. I have
No, my lord, not given. We simply, my lord, filed an application. Just initial response was made. Based upon that, they made the adjudication. And my lord, kindly appreciate one thing. How can at that stage, my lord,
And
an
there was an
allegation-
appeal also. There was an appeal.
Yes,
Yes, appeal also is
It,
there.
it was raised that hearing was not given.
Yes, exactly, my lord.
Where is that?
Yes. Appellate order
No, in the appeal, page 247.
is 247, yes, my lord.
Whatever else. There was earlier repetition.
Yes, yes.
Yes, Lordship. I'll come to that, Lordship.
Lord, because in the meantime, blacklisting came up, we filed against this show cause.
Okay.
Please come to page 252, my lord.
Hmm.
Roman 2, my lord. Oil's failure to provide disclosure of the relevant documents leads to an assumption that mandatory precondition prescribed under clause 8 of the banning policy for issuance of show cause notice for debarment have not been complied with. The show cause notice having been issued in violation of the provisions of the banning policy is bad. Debarment order is in violation of Rule 151(4) of the GFR issued by the Government of India, which categorically mandates that bidder shall not be debarred unless such bidder has been given a reasonable opportunity to represent. A reasonable opportunity also includes access to all relied upon documents, denial of documents, and hearing before passing of the debarment order, vitiates the proceedings and call for setting aside of the debarment order. Specific ground taken, Miller.
Okay.
So my humble submission at this stage.
Just this FIR, sorry,
Yes.
so-called notice,
Yes, Miller.
which was
Page
issued
112.
to you
Page
on
112.
29/7/2025.
Yes.
Whether all these FIR and all these charges were submitted.
No,
Supplied to you.
No, Miller. None of the, that's the ground which I have read just now, Miller.
Mr. Sharma.
I have answer to that. May I submit, Lordship? If a Lordship will come to that, because there has been a pre-proceeding before today's case, that earlier repetition. There has been certain development there also.
Earlier repetition we filed against the show cause notice. During the pendency of the repetition, since debarment order was passed.
Let us see the order. Let us see the order after the so-called notice.
Page 240, Miller.
240. No, not that order. That
The order of the High Court.
No. That order, banning.
Oh, banning order is at 246, 243.
243. 10th of October order, Lordship.
Please come to page 244, Miller. They themselves say it is a preliminary response. Para 4. And whereas UDTL submitted their preliminary response by letter dated 13/8/25, requesting documents related to internal proceeding, extension of time, and personal hearing. In later, it was further contended that the same criminal case is under investigation, and so far no judicial order has been passed convicting the company or any of the official. They have also referred to Rule 151 of the Rule 151 Debarment for Bidding of General Financial Rule issued by the Government of India as revised on 31/7/24, wherein debarment is stipulated to take place only after conviction of an offence. And whereas All India, by later dated so-and-so, was duly informed that internal process documents could not be shared and that their preliminary reply submitted by so-and-so would be treated as a final response in case of non-submission of their filing reply, if any, within the extended time of 15/9/25. So the said letter dated 6/9/25, the company was once again informed that any personal hearing, if any they desire, would be arranged within. My lord, if they do not
Yes.
give us the material based on which they would like to proceed, am I not prejudiced if it is not provided to me?
The materials given in the court proceeding itself. I'll just place that order. Materials produced.
No. Okay.
My lord, will kindly come to page 115 for a moment, my lord.
Now, Mr. Sharma,
Yes, Lordship.
Please come to 115 for a moment.
244,
244. Yes,
244, yes.
6.0.
6.0. Yes, Lordship.
Instead
Last
of,
line,
Yes, Lordship.
requested for personal hearing. Was
Yes,
it
Lordship.
given?
Why I did not give? Because
Was it given or no?
it was not availed by them. Because what they have stated in their own letter, after I file my final reply, I will intimate, give me a hearing. That is there on record. The document is on their own record.
No. Page 244, it is your order.
yes.
Yes.
They have submitted another reply to the oil show-cause notice by letter dated
3/10/2025.
2025.
Yes, Lordship.
Reiterating their
Yes, please.
submissions made in their preliminary
Reply of 13/8.
13/8/2025.
Yes, Lordship.
And requested for personal hearing.
Yes.
Right.
This.
But what does it observe? This order.
Yes.
This order, what does it observe as regards personal hearing?
The last paragraph, Lordship will read, paragraph 7 then. I'm just reading. That whereas the GFR rule 175, which speaks the procuring entity after giving reasonable opportunity of being heard, comes to a conclusion that the bidder or prospective bidder, as the case may be, has contravened the code of integrity, may take appropriate measures. Hence, as stipulated, Messrs. UDTL was given with ample reasonable opportunity to defend, place their case, including the opportunity of personal hearing, because in the original so-cause, we have given another opportunity, which they could not avail by not submitting their final so-cause reply in time.
How can you presume? This paragraph 6 says that they have submitted reply.
Yes, that reply is barred.
Reiterated the submission.
So that reply is barred by a previous order of this honorable court, if I may just produce that. That's what I'm saying. This has been concealed. This one has been concealed. The earlier proceeding, where they had challenged the so-cause, in open court, I had submitted the papers to them. It was recorded in the court's order, and the court gave them 7 days time on 24/9 to file their reply. They have not objected to that. They have not come up on any review extending the time. From 24/9, 7 days will not be 310. So 310 is beyond the court's order.
Let us see.
Yes, Lordship. We are following the court's order, Lordship. This is WPC number 5719. If your Lordship will come to paragraph 6. My other senior friend was not there in that case. Paragraph 6. May I read, Lordship? The learned senior counsel submitted that though on 29/7/2025, the petitioner was issued a so-cause notice, but the basis on which the so-cause notice was issued, or for that matter, the action which was taken for suspension of the petitioner, that particular document has not been provided to the petitioner. And in that regard, the petitioner has submitted a preliminary response dated 13/8/2025, wherein again request has been made for furnishing of the documents on the basis of which the petitioner has been put under suspension. The learned senior counsel further submitted that till date, the said document has not been forwarded to the petitioner, and it is under such circumstances the proceedings for banning of the petitioner's firm, which was initiated on the basis of the Community Letter 29/71, has been continuing, and the petitioner has been put to great disadvantage on account of the suspension. Now, if your Lordship will come, I gave my submission regarding the clauses of the contract and the banning policy. Now, if your Lordship will come to paragraph 12. Last page, paragraph 12. This court duly takes note that the document which has been sought by the petitioner is furnished by Mr. A. Sharma, the learned counsel for the respondent, and Mr. R.B. Fukon, the learned counsel for the petitioner, to the learned counsel for the petitioner during the course of the hearing. The petitioner is given the liberty to file the final reply within 7 days from the date from today before the competent authority. This is an order dated 24/9/2025. There is no appeal. There is no miscase filed by them for extension of this time, Lordship.
That is the same petition or what?
Same petition, Lordship.
Where it is annexed, the order is annexed?
Yes, my lord.
Which one?
This order.
240.
This order, Lordship.
Relevant portion is at 241.
249.
However, Kolita Standing Council submits as regards conflict with the petitioner, the same had been already been cancelled. And in that regard, a communication has been placed
This
before
is a
the
subsequent
court.
order, Lordship.
The same is kept on record, being marked as later X. Thus submits that therefore would not like to further press the instant petition, but withdrawal of the instant petition should not prejudice the petitioner to assail communication dated 12/12/20. So in the
24/9.
meantime, my lord, 12/12/25 contract was terminated. Therefore, my lord, with liberty, the first writ petition was filed. The last paragraph is closure of the instant petitioner shall not prejudice the petitioner to assail the communication dated so and so.
So this order is not a part of the writ petition. I will not use the word concealment, but this order is not a part of the writ petition, wherein the two arguments regarding the non-furnishing of documents has been taken care of. And the court also passed a direction that within 7 days, you file your final reply. And there is a letter on record wherein they themselves have stated only after the final reply, after 2 days, we want personal hearing. So the final reply never came. The letter that came of 310 is beyond the proceeding time or the banning proceedings period. And we proceeded based on the 13A, which has also been communicated to them in the series of communication that have happened prior to the filing of the earlier writ petition, which is also a part of the record. I may place those documents also to indicate the sequence of communications been made. Page 119 is a letter by them, wherein they themselves have stated, I'm just reading that line. We also request you to kindly grant us opportunity of personal hearing on any date thereafter at your earliest. The earlier paragraph is, we crave liberty to file additional reply after filing of the document so and so. And then they say after the
It seems that page 245, this cognizance order, you have taken note of behind the back of the petition.
behind.
Page 245.
Yes, Lordship.
Which influence your decision. Cognizance order has influenced your decision, 14/8/2025, which was not part of the show cause notice.
So I do not have the records of this proceedings, what has happened in the banning. But obviously,
Whatever the impugn order has come and appellate order has come,
this is
but still,
yes,
you file your reply within 7 days.
I'll do
You're
that.
doing it, keeping it at motion stage.
The banning order is 10th of October. Today we are in March.
No, we are keeping it at the motion stage. You file your reply. In
do
other case also, I have directed them to file a reply, IOCL, ONGC, so far
Yes,
as
yes, I'll
banning
do
is concerned.
I'll do that, Lordship.
This may have to be revisited also.
If necessary, yes.
If
definitely.
necessary,
If
this order has to be revisited.
Yes.
But
Today is for the first day.
at least, yes.
I am submitting all the documents available on
Yeah.
record.
This show cause notice was not there. In the show cause notice, this 14/8/2025 cognizance order was not there. Right? But you taken note of the submission of charge sheet.
Lordship, so-called notice was of July.
Right. That is why.
Therefore, it could not have been a
That
part.
is why.
I understand. Yes.
14/8/2025 cognizance order
Yes.
seems to have influenced your decision.
That the records
Charge
will
sheet,
reveal.
because it says that charge sheet.
Yes.
Public order publicly made. This is the record. What else record is required? Public
Right.
order publicly made.
So if that is to
MS
be
Gill.
taken into account, if the charge sheet is to be taken into account, first charge sheet, even they are implicated.
Yeah.
Even they are implicated there.
Yes.
And so far as that work order dated 3/3/2025, right?
Yes,
Contract
Lordship.
work.
Yes, Lordship.
And it seems that 245, that very charge sheet and cognizance order has influenced your decision. If that
This
is
is-
the basis, then that opportunity should have been taken, because this is a new material.
Yes.
Initially, it is FIR.
FIR.
Show cause notice is FIR,
FIR. Yes, Lordship.
right?
Yes.
But the decision you have taken on the basis of charge sheet. 245.
245, yes.
Yeah.
It also indicates about the charge sheet, yes.
Yes, not indicates. See,
it gives
the
second order.
text and tenor of the language.
Yes, Lordship.
245.
Yes, I have seen that, Lordship.
The said FIR has now been registered as so and so.
Yes, first they talk about the.
Wherein the court, now court has come in.
Hmm.
While this order dated 14/8/2025 has taken cognizance of the offence
Yes.
and against the accused persons named in the charges, including the company, that has influenced your decision. That material ought to have been given that liberty or not. But if new materials and primacy materials
Yes.
have influenced your decision, then those materials ought to have been provided.
So the banning.
Perhaps. I'm not into the banning. I am into the principles of natural
justice.
That's all. I'm not into.
Because this is ultimately.
You may be right.
Ultimately, this is a banning jurisdiction we are looking into.
Yes.
Here,
That
so cause and a reply.
Yes.
Supreme Court has said. Supreme Court has said it is so cause and a reply.
No. Supreme Court has also said if something, you are an adjudicating authority.
Yes.
And be it a quasi-judicial or administrative.
Yes.
If something has influenced your decision, then that materials
That
ought to have been
Provided.
no dispute on that legal
otherwise it is
proposition.
in violation
No
of
dispute
it.
on the legal proposition.
That is a proposition only.
Correct, correct.
I'm not into the banning
So,
thing.
but
Your power is inherent.
Yes.
No doubt.
But you have to follow the procedure.
so the guidelines
And the procedure.
our banning guidelines prescribe the constitution of a committee. The committee will go through this entire thing. I don't
File
have the
your
committee-
reply.
I don't have the committee report with me. This is the final order communicated to him.
I'll ask you to reply.
10 days
Respond.
also. 10 days. This is a bulky.
I'll ask you to reply, at least more particularly on the aspect.
Yes,
Because
also.
I am not questioning about your jurisdiction to put somebody on blacklist.
I understand also.
But only the question is the procedure.
Yes.
The decision is yours.
It's true. That is true. That is
That's all. And this is a drastic action.
Yes.
So at least all principles of natural justice are
Has to be followed.
That's
And
all.
Lordship's query is also very significant on this point.
Severe, my lord. Supreme Court says it
The
is
more
all-
severe.
all the more necessary to follow the principles. of
Like
natural
NDPS
justice.
Act.
Yes.
I understand. Lordship will give me 10 days
In
time
NDPS Act, it is 20 years or acquittal.
for acquittally. Nothing in between.
Nothing in between.
Lord, I was only praying for my lord if it that
10 days. Motion.
motion.
I'm not keeping it. He's there representing all.
Oil. Yes.
Yes.
All, yes, Lordship.
Then we'll make the notice returnable forthwith.
Okay.
And also, this is the order of 10th of October.
Anyway,
So just to
right,
give me,
right.
so that I can buy some time from him. Therefore, I'm placing this thing. 10 days.
10 days.
Yes,
So
Lordship.
put it, but 10 days holiday will come.
Individual
I don't
election.
Okay. Adi hol 60. 30.
30, yes.
30th of March. Yes, Lordship.
Okay, more than 10 days.
Obliged.
Lord, could it be 26th, my lord?
30th.
Yes, 26 तारीख की है.
So that I can properly file, Lordship.
Okay.
I have put many cases, so if
30.
30th returnable, 31st will do.
Or let it be 30th, my lord.
38th,
30.
third. I'll just put this small question.
Yes, Lordship. Okay.
But otherwise, you respond.
I'll file a detailed affidavit, but more particularly responding on this query of Lordships.
Third, Mr. K. N. Chori, Learned Senior Counsel, assisted by Mr. D. Kashyap, Learned Counsel for the petitioner, and Mr. A. Sharma, Learned Counsel for the respondent. OIL authorities. Full stop. The petitioner was served with a so-called notice
29/7/2025. 112.
was served with a so-called notice
112, Lordship.
dated 29/7/2025, asking it to show cause as to why the
The lordship's kind permission, my lord.
shall not be placed under suspension with Because as to why the petitioner shall not be put on holiday list and debarred from carrying out any business with Oil India Limited. In response, the petitioner in a so-called notice, it was mentioned that it has been reported through alleged about commission of corruption by the petitioner company, including two officials in collusion with an officer of oil while dealing executing orders of Oil India Limited. Full stop. Mention was made of an affair registered as RC 2172025 capital A 0012 dated 3/5/2025, stating about the arrest of one officer of the IOL, oil. And the affair was on the subject corruption and bribery of public servant by private person and commercial organization in criminal conspiracy. In response to the so-called notice, a reply was submitted by the petitioner on
13/8/2025.
13/8/2025. Upon a litigation in the form of WBC number 5719/2025 ensued in the interregnum. Finally, the impugn order dated 10/10/2025 was passed by the competent authority in the oil, whereby the petitioner company has been placed under the holiday list and debarred from participation in oil's future contract for a period of 2 years. WEF 29/7/2025. An appeal preferred against the impugn order received dismissal at the hand of the appellate authority on 15/12/2025. So thereafter, the instant petition is preferred. There are one of the contentions raised on behalf of the petitioner is that in the affair, in the so-called notice, mention was made of an affair registered on 3/5/2025. However, in a subsequent period, the investigating authority in the case, RC so and so submitted a charge sheet on
27/6/2025.
27/6/2025 and a supplementary charge sheet on 22/02/2025.
22/12 plus.
22/12/2025. Post up. It is a contention is advanced to the effect that the impugn order dated 10/10/2025 has been influenced by the fact of submission of the charge sheet and a order of the court dated 14/8/2025 taking cognizance against the accused persons in the charge sheet, including the company officials of the petitioner. Post up. It is thus contended that the materials which have influenced the decision, of the competent authority in the oil were not put to the petitioner. Post up. The petitioner has also highlighted that in a supplementary charge sheet, the petitioner and the petitioner company and its officials were given charge sheet in respect of a number of matters. I'm not saying that 3/3/2025.
Yes, Lordship.
The matter would require consideration, post up. At least, Mr. Sharma has submitted that the reply of the respondent oil authorities can be filed within 10 days' time. Post the response, counter affidavit. The counter affidavit will also address the aspects highlighted by the petitioner.
Actually, it was by this honorable court.
Post up. Raise the case again on 30/3/2026 for filing of counter affidavit by the respondent oil authorities. You want any copy extra?
Yes, one copy. is
Mr.
there.
So-and-so, Land Council for a petitioner shall furnish 2 extra copies of the writ petition to Mrs. Sharma during the course of the day available. Or by tomorrow.
By tomorrow.
By tomorrow. Meanwhile, this highlight.
Yes, Lordship. We are obliged, Lordship.
No.
For this patient hearing, it's already 1:20 now.
What to do?
Lordship, if I may, Lordship, an interim protection may be granted till the time.
What appellate order, this order?
Delay on their side has to be
Delay
approved
also
in-
10/10/2025.
After 5 months, they have come.
Where is the appellate order?
15,
wait
12,
10 days,
15,
sir.
12,
You
15,
wait
12,
10
15th of
days.
December. Appellate order 15th of December. 3 months.
3 months. How can it be?
And staying the ban,
Wait
you would
for
like
10 days.
giving them final relief also, Lordship.
That is almost the final order.
Yes, Lordship.
Okay, anybody for item 12?
Obliged, Lordship.
Because this court will rise early. We can continue. If some, okay. 9 was it?
Obliged, Lordship.
9. Item 9, anybody is available? 9. 12? 12, 9. Okay then, we'll come back.
Daily list item 9.
Happy the Lordship.
Yes.
My lord, this is regarding non-payment, my lord. Earlier, at one point of time, the petitioner approached, my lord, in 2014. Then it was disposed of, my lord, by to follow the Tamsirali. And my lord, the petitioner, along with other identically situated contractors, my lord, had approached the authorities by filing a representation, my lords. Lordship will find the work order at page 13, type copy,
Page 13.
page 13. Work order of 2008.
Third, Mr. D. Gugoi, Land Council for a petitioner. Mr. S. Dr. Water issues,
No, water resource.
Miss, on behalf of Mr. Arindas. Resources Department, sir, the rest standing council. 1, 2, 1, 2, 6, 7, and 8. As Dr. the standing council. Eviction Disaster Management Department for the respondent number 3 and 4. And Ms. U Das, learned additional public prosecutor, additional senior government advocate for the respondent number 5. First of the petitioner has opposed this court, stating that an amount of rupees 2 lakh, 44 lakh, 39,542 has remained outstanding to be paid against a contract work executed by him pursuant to an work order dated 34/2008. Post of the petitioner had earlier approached this court by way of a petition from a WBC number 2814/2000.
Petition number 934.
934.
94, page
Which-
17. And
Page
it's a
17. 934/2014. And the petition was disposed of by an order dated 21/2024 to direction to the responding authorities to consider the payment of the contractual bill of the petitioner in terms of the guidelines formulated by the decision in Authorised Ali versus so supra. So stuff. When the petitioner sought information from the responding authorities under the Right to Information Act, the responding authorities through the state SPIO informed that the amount has still remained outstanding to be paid. Seeking a direction to the responding authorities to disperse the said amount of which so and so the instant petition is filed, issue notice returnable on so and so, as so and so appeared accepted. Notice, no formal notice, extra copies within 2 working days from today.
2904. 2904. Item number 12.
Madam instructions, my lord. Yes, NIT they have has been cancelled.
Okay, Mr. A.K. Ajad, learned counterpart of petition has submitted that the subject matter of the petition has become infectious. Miss E.S. New, learned standing counsel. Irrigation department is present. So in view of the above submission made by Mr. Ajad, learned counterpart of petitioner, the petition is dismissed. Being infectious, it's dismissed.
Supplementary list, item 36. Item number 36.
There is no representation on behalf of the petitioner to be on call. Miss E.S. New, Land Standing Council, Irrigation Department is in attendance. In view of non-representation on behalf of the petition is on call, let the case for ends of justice be listed again on Wednesday. Wednesday.
Next Wednesday. Wednesday. 18. Item 38.
On the matter relating to removing of the name of the petitioner from the voter list.
Similar order has been passed, detailed order in this matter.
Yes, my lord.
But 7 days now don't remain.
Also, in this case, in fact, the petitioner has also have started availing the statutory remedy by filing an, because if your lordship comes to the writ petition, page number annexer 5, page number 114, lordship.
140.
114.
Petitioner names, my lord, in fact.
114, lordship. 119, lordship, sorry.
119.
They've already approached the district commissioner, lordship. With that,
Whether he is a proper authority.
My lord, the petitioner names are in the voter list
RPA.
recently published, final voter list. Their name were there. But subsequently, from the website, the name has been removed without any.
How do you say that the final voter list?
Yes, we charge, my lord, and no result found shows, my lord.
If the name is there in the electoral roll, then it will be there, lordship.
Then, my lordship,
let him wait for the report from district election commission, district election officer. If he says that their name has been deleted, or there is any grievance, then he definitely has the forum of chief electoral officer, lordship. as per section 24 of the RPA.
If there is any
Lordship,
grievance, they
Lordship,
put us-
because Lordship may give a direction that this maybe
I annex the voter list, my lord.
Right,
The
so
26.
when it was published.
When published of my lord,
versus
10 to
10th
26,
of February, Lordship.
10 February, my lord.
10 February. Now,
Yes, my lord.
you are saying that your names were not
Their names are there.
They are in the voter list, my lord.
How can we know?
That's not. If it is.
You say that it is in the voter list. Then again you say the names of the petitioner along with their family members.
Well, removed from the website, my lord. Electoral commission.
Website.
Electoral roll is the main
Huh.
website. Maybe some technical glitch, maybe something.
Maybe can you
I can update instructions.
It's about.
can you verify whether their names are there?
Lordship, I can verify, Lordship. Today's
Maybe in the web list may not be there.
Lordship, maybe because of some technical, because as the voter list that they have annexed, Lordship, their name is there, Lordship, and it's not been deleted in there, Lordship.
Instruction.
The instruction was certain.
Because there is one difficulty in section 23, if I may say so. See, we discussed that day,
Yes,
23,
Lordship.
uh,
Inclusion of names.
subsection 3, no amendment, transposition or deletion of any entry shall be made under section 22. And no direction for inclusion of a name in the electoral roll of a constituency shall be given under this section after the last date for making nomination
That is still there.
for an election in that constituency, right?
Yes, Lordship.
And before the completion of that election.
Lordship.
Now, if you count 16 days,
Lordship.
today is 16th,
Lordship. It's on 23rd.
7th day will be 23rd. 23rd is the last day
Last
of
one, I know.
nomination. Now come to the rule,
Lordship.
which we mentioned that day.
Lordship.
What was the rule? 24 perhaps.
Lordship. Lordship 26. Lordship.
26.
6.
There you see that application is to be in the conspicuous place,
Lordship.
inviting objection within a period of 7 days.
Lordship.
So this 7 days is counted.
Lordship. That's why I am saying, Lordship, he has already filed the application to the district commissioner, Lordship. So since he has filed the application, Lordship may direct that the application will be disposed of, Lordship, and he may be provided the requisite information whether his name has been deleted or not. At least he will get the
But who is the authority?
district. Lordship, Sribhumi, generally district commissioners are only the district election officer. Authority will be district election officer, Lordship, as per the RPI.
But it is a registration officer.
Electoral registration officer, Lordship.
Ah.
But the appeal lies before the, your Lordship, district election officer. First appeal as per section 24, and the
But
second
we are into
whether his name is deleted or not, Lordship.
we are into section 23 only.
23, Lordship.
23, whether that electoral registration officer is the deputy commissioner.
Electoral election officer, not the deputy commissioner. Sir. He is the district election officer. Lordship.
You have come late, Mr.
Lordship.
I
To pass
already
similar
filed,
order, 7 days are to be given by the electoral registration
lord,
officer.
I filed my application before the deputy commissioner on 2/3/2026.
But he is not the authority. He is the appellate authority.
Appeal, Lordship.
Whether their names are, he is saying his names were there.
Yes,
Yes,
in
yeah.
fact, as per the final rule, his names are there, Lordship.
Can you find out?
Lordship, I can, Lordship.
Yes.
He is saying no result found.
No.
No result found at the website, man.
Maybe some website is difficult, but he himself has annexed the electoral
Yes,
roll
yes.
where his names are there, Lordship.
Which one?
Lordship.
Page?
Lordship, for annexer 1, it's from page number 29, Lordship.
This is of 10 to.
10 to Lordship.
This is certain here, certain voter list is annex of
Yes,
27, 12,
my-
25. But
Petition number 1 at 7:30, last one.
now, will also come to page number 35.
it is in the draft electoral roll.
No, final electoral.
He is saying that I have to verify,
Final
Lordship.
electoral.
I have to verify, Lordship.
You find out.
Published on
There is-
27/12, my lord.
But period is less now,
Yes, Lordship, that's
right? And this has to be kept in abeyance before completion of that election.
election, Lordship.
Electoral officer is statutorily not empowered
Not
within that period. Last date of nomination and before completion of the election.
Commission of
That will be 3rd or 4th May.
Third and fourth amendment.
Thereafter they can do.
They have to
But
take
if
it,
their
Lordship.
names are already there, no.
No,
Yes, but
where is the
already
Lordship?
there. Already
If their
there.
names are already
I
there,
don't
no.
know. How can I know, Mr.
My lord.
Yeah. Unless they confirm.
Lordship.
Yes.
It's fine, fix them day after tomorrow, Lordship.
Monday,
Yeah, Lordship.
get the instruct. Oh, sorry, day after tomorrow.
Lordship.
Okay.
Wednesday.
Third, Mr. A.J. Atia, learned counsel for the petitioners, and Mr. A. Ali, learned standing counsel, election commissioner of India for the respond number 2
That's one number 2, 4, 2 and 4.
and
2, 4, 6 and 7, Lordship.
6 and 7. UDAS, additional senior government advocate. 3, 5 and 8. Most of the petitioners have stated that their names were enrolled in the recent voters list published on 10/2/2026. Post of
My lord, kindly see page 30. Published date 27/12/25 1 and
page
page 29,
published on 27/12/2025.
25.
That is perhaps draft.
That is a draft, Lordship. But they have annexed in page number 39.
That-
Again,
draft.
my lord?
27/12/2025, right?
Yes,
Anything else?
no one.
That is draft, I think.
That is- In my sense, that may be the draft, Lordship.
And my lord, kindly see page 60. Page 60.
I know your anxiety, Mr. Atia, but question is that
Page 60, my lord.
the similar order, the order which was passed in the other one, they came in time. Now
My
the
lord,
difficulty, have you gone through the
I'm sorry, my
provisions?
lord, I came late, my lord.
Mr. Atia, have you gone through the provisions of section 23?
121, my lord. kindly
Mister,
see.
have you gone through the provisions of section 23?
My lord.
Have you gone through yesterday's notification, election commission?
Yes, yes.
The time is less now. Time is not there. So only thing we will find out in the draft electoral roll published on 27/12/2025 for Patharkandi Legislative Assembly constituency, district Sribhumi within bracket previously Karimganj, bracket close, Assam. Full stop. After the recent, when after the recent special revision of the electoral rolls, the petitioners checked the website of the Election Commission of India, they found to their surprise that the website indicated quote unquote, no result found. Full stop. Apprehending that the names of the petitioners have been deleted from the electoral roll without an opportunity being heard. The petitioners are before this court by the instant writ petition. First of the petitioners have mentioned their EPIC numbers. Where? Numbers?
Numbers, my lord.
No, not there.
Yes, my lord.
Have annexed their EPIC documents as annexer 4 series.
That's all.
Within brackets is number 100 to 118. Post of Para. Mr. Ali shall apprise this court whether the names of the petitioners are enrolled in the final electoral roll published for Patharkandi LAC, District C, Rumi, in bracket, previously Karimganj, Assam, on the next date of listing. This the case on month Wednesday.
Extra copy may be furnished to me during the course of the day.
Mr. Atia, Learned Counsel for the petition, has furnished a copy of the petition along with an annexure to Mr. Ali during the course of the day.
Item.
Let me see, Lordship, my lord. I have missed the item number 36. my lord.
After some times. Today we are running short of time.
My lord,
Let the other matter be called
my,
thereafter.
39.
My lord, I understand Lordship has fixed a similar matter on 23rd.
All this because of this Tata Motors
Yes,
document,
yes,
right?
Yes, yes.
The otherwise in India, Tata, Ashok Leyland,
These are the two.
mainly these two. 10,
But
15
only
years,
this is, my lord,
5-10 years back.
the oil company's own circular says for verification, go to RTO. In fact, when we place the vehicle before.
Where is the document?
Yes, yes.
The Tata.
Yes, yes. My lord, if your lordship should kindly come to this.
Page 263.
263.
This is a bit vague.
Yes, yes.
This is a bit vague.
Otherwise, citizens will be taken for a ride, my lord. When I buy a second-hand vehicle, all that I can do, I can go and check up from the RTO office. And lordship knows there were amendment of the MV Act.
Is there any counsel for Tata Motors who regularly represent Tata Motors? Earlier, Mr. J. Roy used to.
Yes, J. used to.
Used to.
Article 9. I haven't seen him appearing for the last couple of years, my lord.
To expedite. Actually.
Yes, yes. I can ask him, my lord.
Huh?
I can ask him.
If you can ask him, then we can proceed. Or otherwise, if any counsel is there, because this is 263 CC's number, engine number.
In fact, Lordship may kindly have a look, page 223. The registration, the chassis number and the record from the transport department is same.
Right.
Yes.
And they have created the mess.
Yes,
My
my
lord
lord.
will kindly come to page 282 for a moment. This is their document, Transport Department. 2.1.3. On final, has a lawsuit got it? 282. On finalization of contract, transporter shall place the truck at a location as directed by the corporation for induction. Before induction of the truck, location shall carry out physical verification safety checks of only those trucks bearing registration number as mentioned in LOI, provisional or final work order. When the truck is physically presented by transporter at location for induction, the authenticity of the truck is physically checked with respect to its parameters like engine, chassis number, punched on the truck vis-a-vis that mentioned in the original document of the RC book, etc. The aforesaid documents also should tell you the documents submitted at the time of submission of the credential bid of the said truck. Once the authenticity of the truck is checked with respect to physical parameters and original documents and cross-verified with the documents submitted in the credential bid, if found tallied in all respect, then only fitness of the truck for induction is checked for safety parameters, otherwise trucks will not be inducted. Then 2.1.4. Documents which are found in order may be checked from Road Transport Authority for verifying the genuineness. So we are relying on RTO document only, Milord. What is the other source for us to know whether it is a Tata make or not? Because the registration number is there. And we do not know in what manner
They keep records.
Yes. Now, if your lordship would kindly come to page 279, these are the reasons for which, my lord, our case was rejected, or rather, we are blacklisted. Kindly come to one.
Final order has been passed.
Yes, my lord. Page 278, it starts. Sorry, 277.
Mr.
And
Decker,
the
can you
operative
find out anybody from Tata Motors? Ask Mr.
Yes, yes.
Right. We'll put in day after tomorrow.
Milan.
This should be expedited. Mr.
Yes, yes.
Kulpa?
My lord, this is an IOCL matter. I was not aware.
Huh?
This is similar perhaps to that matter on
Maybe.
Friday.
Same Tata Motors.
Tata Motors. Then can it be on 23rd, my lord, possibly?
No, let us have some Tata Motor Council is there.
Yes.
23rd, day after tomorrow.
Day
We will
after
try.
tomorrow, let Mr. Decker find out.
My lord, I'll find.
Call him so that we can ask the information from the Tata Motors. How they have gone. From since when they are maintaining records.
Yes.
In what manner they maintain records. Right. That will be easier and it can be expedited.
Yes, it can be explained.
Right.
Day after tomorrow, my
Day
lord.
after tomorrow.
Item number one of the production is the same.
Same. K. Chaudhary, Senior Counsel, Estate by Mr. R.M. Dekar, Learned Counsel for the petitioner, Mr. N. Borua, Standing Counsel, Learned Counsel for the respondent oil case. MD Bora, Standing Counsel,
Transport of 5 manner.
Transport Department, and Sir S. Roy, Central Government Council for Transport number 1. Post of late. Release the case again on Wednesday.
18th.
Mr. R.M. Dekar, Learned Counsel shall apprise this court whether whether there is any standing counsel for Tata Motors Limited.
Yes.
Find out. Same in production list.
Item number one. 1 and 7.
Okay.
In order to the prosecution side of copyright. Yes, Mr. Hawk. Yes.
Item 36. Item number 36. Order no steps. 36.
No, 36.
Sir,
Mr. Hawk,
My lord,
day after tomorrow then.
my lord,
I already put it on day after tomorrow. Now council is not there. This court is rising at 2:45.
my lord, he can obtain instruction, my lord. What happened, my lord, in this case, my lordship, my colleague is holding.
Right, Miss Neog was there
Yes, yes,
already.
Yes.
Neog was there. You were not there.
My lord, what is the urgency is that, my lord?
Yes, we also have urgency, mister. This court is rising at 2:45. Have you seen the cause list?
Yes, my lord.
Day after tomorrow.
They have
Day after tomorrow, they have
already opened the finance bill. That is the reference, my lord. They may.
what to do, mister? You were not there.
My lord, I was in another court, my lord. So-
Now, by the time Miss Neog comes, it will be 2:45. Day after
Tomorrow, my lord.
tomorrow.
Tomorrow, my lord.
Day after tomorrow.
My lord, genuine apprehension, my lord. Finance bill has
Everybody
opened, my
has
lord. They will-
genuine apprehension,
Probably,
mister.
my lord, they have already allowed the, my lord,
You
LOA.
don't know.
Order no steps. Item 13.
Wednesday, Wednesday.
My lord, apologies, my lord. We submitted the steps because of some default, my lord. It was probably not dispatched. But anyways, the respondent has appeared. My lord.
Yes, the petitioner sent us a copy of the order through WhatsApp.
Huh?
I have filed my appearance, Lordship, on behalf of the respondent number 6.
You are respondent number
6, Lordship.
6.
But Lordship, steps were not taken, therefore I do not have a copy of the
My
petition.
lord, I'll furnish him today. I'll furnish him.
Okay, Mr. P. Pathak, Learned Counsel for the petition, and Mr. P. Nayak, Learned Additional Advocate General Assam. For the respondent number 1, 2, 5 are present. Mr. A. Chakraborty, Learned Counsel, has submitted that he has entered appearance on behalf of the respondent number
6, Lordship.
You have got copy of the
No, Lordship.
I'll furnish today only.
Mr. Pathak, Learned Counsel for the petition, shall furnish a copy of the petition along with an annexure to Mr. Chakraborty during the course of the day. Post of release the case on Friday.
Lordship,
Friday?
I may not be on, Lordship. Can it be on Tuesday or Wednesday?
Huh?
Next Tuesday or Wednesday?
No Tuesday.
Wednesday, Lordship, next Wednesday.
Lordship, may I submit, Lordship?
Already notice has been issued.
Yes.
File the response.
Lordship, I have also received instruction, Lordship. I am filing my affidavit.
Both of you file the response. How much time, Mr. Nayak?
Lordship, at least 2 weeks time may be granted.
Okay. Both Mr. Nayak and Mr. Chakraborty have prayed for and are granted 2 weeks time to file their respective counter affidavit. List the case on so and so. The interim order of Australia shall continue till the next.
84. 0804.
84.
Item number 14.
May it please, Your Lordship. Pay for the railways in this matter, probably it has become infractuous. It's regarding non-renewal of the vending license.
Absence in how many days?
The
One occasion. On third occasion, we'll do it. We'll put it on next Friday. There is no representation on behalf of the parties, on behalf of the petitioner today on call, Mr. B. Sharma, Learned Standing Counsel, NF Railways for the respondents is present. In view of non-representation on behalf of the petitioner today on call, let the case points of the 6, be listed again on Friday.
2703.
27. Let it be 28. There's some family function, my lord. 25th and 27, except, my lord.
Okay. Today is what? 16.
16.
Okay. 23rd.
23rd. March.
Otherwise, it will be listed on 20.
20. 20 I'm available. I thought 27.
No.
20. Item 17.
That's it. Today we have filed our affidavit.
File.
That's it.
But today I received, but I don't know, I will not agree.
That's this.
Or Mr. N.C. Das, Learned Counsel for a petitioner, Ms. N. Bora, Learned Standing Counsel, Panchayat and Rural Development Department for the respondent number 1, 3, and 4, and Mr. Ms. U. Das, Learned Additional Senior Government Advocate for the respondent number 2. And Ms. Bora has submitted that the affidavit or counter affidavit on behalf of the respondent, Panchayat and Rural Development Department authorities have been filed today. First of release the case on so and so with the affidavit, counter affidavit of the respondents, state response on record.
2703.
I need to file in
27.
this
You have received?
I
Okay.
have received.
Okay.
And
Office to trace out the
27.
take
Zero
the counter affidavit, the case record. Mr. Das has prayed for and is granted 2 weeks time to file an affidavit in reply. First up, release the case on so and so.
64.
Done.
6th April.
God bless.
Item 18.
In this case, readings are over, Lordship. May fix a date for final disposal, madam.
Release. You are for the petitioner?
Yes, madam.
As Somoria. Petitioner. Where is Chauhan? You are for 3 and 6. Who is for Udas.
Yeah, that's fine.
You're for?
District Commissioner, please.
Okay, Udas. R. Chauhan, 3 and 6, 3 to 6. Okay. Any BTC? Mr. NR Sharma. Standing Council BTC. 7 and 8. District Commissioner Chairman, can you be tell it?
My lord.
Yes.
Okay, Ms. Udas. Learned additional senior government advocate, quarter respondent number 2. Any, Mr. Roy is there, sorry, CGC. Okay, the land council for the parties have submitted that exchange of reading is complete. After Bihudan,
My lord.
any hearing on a hearing, that is the case also.
Lordship, only humble pay. If any date, my lord, up.
After, I have.
Yes,
2804.
no problem. Much problem.
Items 19 and 20.
PWD affidavit? No.
No, my lord.
See the instructions, 2 weeks may be granted, we'll file it.
Receive instruction. Okay. Mr. BJ Ghosh, Learned Counsel for the petition is present. Miss
A Board Thakur,
A. Bodhagur, Learned Counsel on behalf of
appearing on behalf of P9.
Pina, Learned Standing Counsel for PWD has submitted that the necessary instructions to file the counter affidavit are received and has thus sought for listing of the case after 2 weeks in order to file the counter affidavit. Post of the praise allowed, list the case all.
My lord.
Again, giving it. I'm not giving it.
Aye.
After
8484.
8-4.
Obliged.
cases.
21.
May it please your lordship. My lord, in this case, we are filing the affidavit in opposition in the course of the day.
Okay.
May I please be taken up on 20?
We have received the copy.
Do you want to file any reply?
Yes.
Okay. Heard Mr. C. Paul,
Yes.
Learned Counsel for the petitioner, Udas, additional senior government advocate Assam for the respondent number 1 and 2, and Mr. N. Borua, Learned Counsel for the respondents. Oh, not 1 and 2.
I am
Not
for
1 and 2. 3. Udas 3. N. Borua,
1 and 2.
1 and 2. Mr. Borua has submitted that the counter affidavit on behalf of the respondent number 1 and 2 has been filed today, and the same is not on record. Mr. Paul has sought for and granted
3 weeks.
3 weeks.
3 weeks time to file an affidavit in reply. Post of the list the case on so and so. The interim order past shall continue till the next date of listing.
2704.
27. Nice matter. Much appreciated.
Item 22.
PWD again.
Yes, me.
Lordship awaited.
Waited. Instructions waited.
Lordship.
They are supposed to file affidavit.
2026, they go slow. Mr. BJ Das, Learned Counsel for the petition is pending. Miss A. Bodhagur, Learned Counsel, appearing on behalf of Mr.
P Nayak.
P. Nayak, Learned Standing Counsel PWD for all the respondents, has submitted the necessary instructions to file the counter affidavits are awaited and has sought for further
3 weeks time, Lordship.
3 weeks time to obtain the necessary instructions and to file the counter affidavit. Post of the praise allowed, is the case on so and so. The interim order passed and shall continue till the next.
2404.
Obliged.
Item number 23.
Lordship, this case, Lordship, parties may dispose of in the line of tomcillary law.
Have you received any instructions?
No, Lordship.
Huh?
Not received, Lordship. In that case, Lordship, I have need some time, Lordship.
No, otherwise.
Not a payment is, Lordship, in the lower side. That is why I am submitting, Lordship. 1,38,459.
Okay. Tomorrow then.
Lordship.
Paucity of time.
Lordship.
Okay, M.A. Hussain, Learned Counsel for petitioner, and Mr. N. Upaidar, Learned Standing Counsel, Eviction Department. No, we will not go by time, sir. We will simply direct to dispose of.
Lordship,
To pay the amount.
Lordship, the Chief Engineer will verify, Lordship.
Lordship.
Okay. Mr. On the prayer, Mr. Upadhyay, Learned Standing Council Litigation Department, list the case. Thursday.
Lordship. Lordship.
Tomorrow again, I'll be rising at
Lordship.
45.
Lordship.
1903. For orders, items 24 to 32.
My lord, the ball has been passed from one respondent to the other. my lord.
Actually, what happened, my lord, it was earlier, it was
It's
additional work was,
some new persons were
My lord, they were
included, right?
included. PWD has already filed a report actually.
uh,
Yes, sir. Madam.
And finance will be involved only when the final proposal is sent for approval, my lord.
Where, in all the cases, 7 and 8 have been implemented.
My lord, yes.
Huh?
Yes, yes, my lord.
Notices have been issued.
Yes, my lord.
Are you sure?
Yes, my lord.
It was also 7 and some, ऐसा लगा दियो. अपनी ये तो item 24. Item 24. Okay, बोल जा. 24. Okay, बोल जा. 25.
No, head file yellow lens.
I do some.
Amended cost title, yes, so what is?
Did you file amended cost title?
Yes, yes, my lord.
Huh?
Yes, my lord. It come up on some other day then, my lord. I'll verify again. I'll cross-check.
Notice was not issued.
My lord.
In this case, notice was not issued
In
to
fact, all the matters that come up together, probably orders were not copied, my lord.
B. Pathak Learned Counsel for the petitioners is present. Full stop. Beleg order saboti.
Maybe separate orders were not
Respondent
registered.
number 7 and the respondent number 8 have been newly included as party respondents. Post let notice be issued to the respondent number 7 and the respondent number 8. Notice is made returnable on later active that the petitioner shall serve copies of the petition along with the annexure to the Learned Standing Council, Finance Department, and to the Learned Standing Council, Public Works Department for the purpose of service of notice upon the respondent number 7 and the respondent number 8 respectively within 2 working days from today. Is that case on so and so? Last one along with so and so. Next, notice were not issued, Mr. Pathak.
Lord, there was an order passed, my lord, but then
No.
not copied probably to the other petitions, my lord. All the matters were tagged together. On the last day.
Same. Item number 26.
Uh-huh.
27. Same. Get I asked any. I asked it. In 6 official 889. Same. Same quality. Same. Item 28, same. It would already আছে 29 of already আছে.
Maybe that was taken as the lead item that day, but because we pursuant to that order, we served copies actually.
But if you ask a guy, immediate cost title yes. 7 and 8. Huh? 7 and 8.
9 2006.
Last order. 31. IAS, no? Same, issue notice. Returnable. 7, 8, huh? Similar. And 32. Okay, notice. List the case along with Baki. Agority Tassel. It look at a
2404.
Who are the 7 you?
Finance and Mr. B. Gogoi had taken notice earlier. For both finance and recovery.
The respondent 7 and respondent 8 shall bring their stand by their respective counter affidavit on or before the next day.
And for 1 to 6. 24 4.
33, 34.
33 and 34.
May I please, your lordship? Lordship, item number 33, lordship. Steps have been completed, lordship.
Last number 2.
Yes, your lordship. In other petition, Mr. K. Gogoi appeared.
2 will be delivered. Okay. P. K. Bora.
PK lordship.
Petitioner. B. Ajurika. Respondent number 3. Z. Bodoloi. Respondent number 4. First of as per order dated 5/3/2026 of the Lojima Code, service of notice of the respondent number 2 is complete. So, as all the respondents are served from a office to release the case in the admission column on so and so, the interim order passed earlier shall continue till the next date of listing. Then the 34 to sound. Here already
Readings complete.
Yes,
Your
reading
Lordship.
complete.
Yes, your lordship.
Okay. PK Bora petitioner. P. Ajurika, respondent number 3. Z. Bodoloi, respondent number 4. Okay, lays the case on so and so along with so and so.
Lordship.
Can a matter be taken next week, your lordship?
Not,
Next week.
not possible.
Lordship. Obliged.
Obliged.
After Bihu.
After view,
Before Bihu, lordship.
before view.
6-4. 6-4. Lordship. Obliged.
Lordship.
35.
Side of the interim order zone as extend for it.
In this case, service upon the respondent 5 is not complete.
5 complete. Okay.
Not complete.
Not complete.
Not complete.
Okay, dear time learning council of petition is present. Peruse the office note dated 12/3/2026. Full stop. 12/3. David for a service report in respect of the respondent number 5, leaves the case on so and so.
After Bihu. Interim order pass shall continue.
Interim order. Pass silence. Before you did.
Before 6 April. 6-4.
Only